What's up, everyone? Welcome to Normal Merrick Show. Having a little difficulty here. Apologize for that. I'm streaming through a crappy old computer only to YouTube. If my computer overheats, I'm just going to do it through the phone. Just forewarning. But I was going to try to bring up screen captures, so I figured I would try it on this old computer that has propensity to overheat and all that good stuff. So I can't do that in the phone. Normally I don't stream on Mondays, but I'm going to try to maybe take some time off when I get home this weekend. I got some things I got to do. Physical therapy, doctor's appointments, family stuff. So I'm definitely streaming Wednesday. That's going to be 2 panels. So that'll be at least a 5 or 6 hour stream. So, yeah. You'll all be able to enjoy that, hopefully, and then we'll go from there. I don't know how much I'll be able to do Thursday, Friday. Now, I don't think Pisco's coming on to debate. He's welcome to, if my computer doesn't overheat, he's welcome to come on, if he's listening. But I was just going to go over our debate that we had on X. Unfortunately, what's liable to happen with the panel I'm on with him Wednesday is, this is a pet peeve of mine. First off, I don't really like panels. I prefer one-on-one debates because I've talked about this before, but even if you have 6 good people or 8 good people, the problem is everyone has different things within the topic that they want to talk about. So it becomes difficult to focus in on stuff. So like if I really want to focus on, part A, and people want to focus that agree with me, but on part B and part C, and the other side's going to have X, Y, Z, and so you end up, it doesn't work well. And then this is, the topic itself, my goodness. Like, I thought this is how it was said to me. It was like, oh, we're going to talk about the Trump trial. I was like, okay. Here is the wording of the topic as it stands now. See if you see a problem with this. Sorry, I'm looking for it here. I got it somewhere. All right, here's the topic. Ready? Weaponization of justice. Are the Trump trials simply being weaponized by Democrats against Trump? Or is this actual justice? Was there any foul play during the trial on the part of the jury, the judge, or any major actor? Or was this above board? And more broadly, when is it okay to prosecute people who oppose you politically? Under what conditions? Or should they be off limits entirely? For me, if you're going to have a panel, you try to hyper-focus on like one simple thing. That's I don't know. Because if you say like, well, there's like, they're all connected, obviously, but if there's like 3 things and you have 6 people and we each, if and you know how it's going to be, Wick's going to be like, well, let's move on to this. So let's say we have 3 areas we move on to, 6 people for 2 hours or an hour and a half. We'll say 2 hours. I mean, 6 people an hour, that's 10 minutes a person. So 2 hours, 20 minutes a person. Divide that by 3. So now you get 6.5 minutes per area to talk. It just seems, I don't know. Anyways, I'm not hopeful that we'll be able to dig into the minutia of this case like I would like. I don't know if you followed my X account here in the past couple days, but you could see that I really like getting into the weeds on this stuff. Thank you, Crisco. I'll renounce my pro-immigration ways. I don't know why it just says, was the Trump trial legitimate or not? What was it? I don't know. But hopefully we can steer in a good direction. But I'm not hopeful that we'll get into a lot of details. So my strategy is going to be to basically pick 1 or 2 things. That doesn't mean that there's only 1 or 2 things wrong with this trial. But that's going to be my focus. For example, I haven't even got into this. I read from the because remember, they didn't want cameras in the court, so you couldn't watch it live. So now there's a transcript, and the transcripts I find more difficult because of the format to read than it would be to just listen or watch a trial. So it becomes difficult because there's a lot of objections and motions, and it's difficult to read. Twitter it's X now, Zen. I think that it's difficult to read through that transcript. So I've read through opening statements, I've read through the jury instructions, but I haven't read through sort of witness testimony much yet. And there's a lot. It's like 4,000 pages or something. So there is zero chance, with as busy as I am, that I'll be able to get through 4,000 pages. I'll be lucky to get through 100 pages. And even when you go through them, it's hard to say something definitively because you don't read it like you read a book. At least I'm not. Not with that many pages. You're sort of skimming it. You're looking for like the first 4 words in every paragraph, and seeing, okay, what's this talking about? And then if you see something interesting, you read through it. So it's hard to definitively say, they never said this. And it's like, well, now it works the other way as well. When you hear people saying, oh no, they testified to this. It's like, where? Can you give me the quote? They ain't gonna know either, right? And I don't blame them. I don't. Everyone who says this is slam dunk Trump's guilty, they're doing the same thing I'm doing. 99% of them, which is because there weren't cameras there and you were unable to watch, and you probably didn't read through 4,000 pages of a transcript, you're relying on what you heard someone that you're listening to as an expert tell you that was either in the courtroom or claims to have read through the transcript. Not 40,000, 4,000, I think. Now, I don't think I'm debating anyone tonight. If someone wants to call in, that's fine. But, by the way, the reason I'm not doing Restream and streaming to all the platforms is because my computer overheats, and I thought maybe it's because of Restream. Right now, it's not making a lot of noise just streaming through YouTube, so it's not that I'm hiding from my Twitch audience or X or Rumble. It's just I didn't want my computer to overheat. And remember, if my computer crashes here, we'll keep up. I'll go on my phone, and I could still stream to YouTube from it. So, have I ever considered being a lawyer? At one point, I did. Like my senior year in high school, maybe my freshman year in college, but then I don't know. So because of that, it's difficult to, let's assume for a second that the case is legitimate, that there's no problem. It wasn't selective prosecution. The jury instructions were legitimate. The charges outlined were legitimate, right? There's no problem with that. Let's assume that for a second. Was the evidence presented in trial enough to prove that Trump was guilty beyond a reasonable doubt? Now, the jury says yes, but would it have been enough do we think that that was a correct verdict? Because I'm reading that there's a lot of people saying, no, it wasn't even close. But I can't definitively say that. I can't, because I didn't read 4,000 pages of a transcript. I could listen to people saying, well, actually, this was the key portion. Cohen's the one who links Trump directly towards blah, blah, blah. And he's a liar, and they admitted he lied, so that's clearly enough for reasonable doubt. Yeah, Hunter's not going to jail. He'll either walk. The 3 options of this, Hunter. He'll be found not guilty, right? Or a hung jury. That's option 1. Option 2 is he will be found guilty and will be given a slap on the wrist. Or option 3 is he will be pardoned. But he ain't doing serious jail time. Guarantee it. Did I read the op-ed from the Washington Journal today? No, maybe I'll check that out here during our stream. So I'm not even going to get into that. That's a 3 to 4 hour debate in itself. So my plan is to focus on what I normally focus on, which was that this was an act of corruption and selective prosecution. And I think that story is easy to tell. Now, I know if you're predisposed to hating Trump, you're going to say, no. But anyone who's remotely paying attention could see that this was a selective prosecution. And we'll focus on other cases that they didn't bring to trial. We'll focus on the bias of the judge, the bias of the prosecution, the legal theories being brand new and never tested, how the threshold for the breaking the sort of case, breaking the glass on arresting for a felony, convicting for a felony, the first time in the history of this country, a president, and you used a legal theory that's never been used before. Those sorts of things is where I'm going to put most of my focus on. And then if I have time, we'll focus on if the charges were charges that were legitimate. That's my goal. So I'm not going to focus a lot on what was said in the trial. Now, the problem with my strategy, though, is I have two people on my side. I have no idea what they'll want to talk about, and I have no interest in coordinating with them. If I did coordinate, if Gibbs is watching or Phil KOE are watching, here's my advice. You two just say, we're going to leave Rob do the talking. That's my advice to you. Now, I will absolutely, and have done this, I will absolutely and fully admit that when I called into J-Stock's channel the other day, it was a poor performance from me at the beginning. For two reasons. One, because I was way too hostile coming into that. And I've already apologized for that, but it's worth saying again. I was, and it's not a good look. I could make excuses. My pain medication wore off, and my back was fucking killing me. And I was a grumpy asshole, even to my family. I gotta get better. I gotta get better at that stuff. I'm normally one of the most, nonchalant, bubbly people, happy people. And I felt myself, with my back killing me here, being a dick. And it's one thing to be a jerk on this channel. I don't really care. I do this for my own amusement. No big deal. It's another thing completely to do it to my family. So, that was not a good look for me optically. And I thank Roland on my Discord for pointing that out. It's not always the easiest to tell someone, hey, I think you screwed up a little. And so, kudos to Roland for that. He's absolutely right. The problem was that any good debater should focus on the parts that they're confident in. Lead with your best foot. That's the problem. And so the problem was that I started talking about something that I didn't know the ins and outs of that much, which we are going to be talking about that same thing, which I've learned more. We will be talking about it tonight. And that's another thing. I say this all the time. What's the worst that can happen? You look foolish, you get proven wrong, etc. Learn from it. It's okay. Most people respect someone who's willing to say once in a while, okay, I was wrong, or okay, that wasn't my best. So it's no big deal. It's not. You're not going to win them all. Now, I don't think I got crushed or anything like that, but it optically did not look great because my opponents knew the details of the ins and outs of how a trial works as far as names of motions, the specific titles of sort of argumentation, parts of a trial, etc. So the other thing that was a problem with it was ultimately that issue, the idea of Trump not being aware of the specific crimes that he was being charged with until basically closing statements. Believe it or not, that is low on the things that were wrong. I don't think anyone's coming on. I'm going to be talking about me arguing with Pisco on X. We're going to look at some X threads, unless someone wants to come on and argue with me. Yeah, it's working, but I've made some adjustments and it'll probably overheat. But so far, sounds good. I think maybe it was Restream causing it to overheat. That was my theory. So we went with that. Anyways, that's not the best argument. So the problem was I came on to that panel and that's what they were talking about. And that's what I jumped on. And it wasn't a smart move. I should have focused more on the issues that I knew more about. But the upside to it is I got to learn a lot more about that specific issue. And hopefully now I have a better understanding. And I think it'll be shown by sort of what we're going to talk about on the X feeds that I've been doing. So that's the gist of the roadmap of where we're going to be going today and sort of what my plans are for Wednesday. Now, someone might say, is it a good strategy to announce on a public video here what your strategy is? Sure, I don't care. Although I'm a competitive a-hole and I want to win debates, I'm actually interested in, having a good, detailed conversation. And so if the people on the other side of the debate see this and say, okay, that's what Rob's going to talk about, let's look into this, great. That's fine by me. So I don't really mind. That's absolutely fine. If Pisco's listening and he wants to call in, he's certainly welcome to. We'll talk about Jabal Bowman first, as we always do, as a prerequisite. But as long as he's okay with that, he's free to call in. In fact, should I tweet? Now, I will say in Pisco's defense, it would not be him running for me if he doesn't come on, because it's not like we agreed. He could, I know this sounds crazy, but he might have a life and something going on. No, my blown up back, it's feeling a little better, I guess, but it still hurts pretty bad. So, got some things in the work. Keep doing physical therapy, stuff like that. So, anyways, where to begin? All right, let's go to my X feed here. Okay, here's a criticism I have of X. Let me show you this. I don't like this. So, I go to my profile on X, and I click Posts. Now, this will only be stuff that I posted. Replies will be stuff that I posted, and then replies to other threads that I posted, which is fine. The problem is with post, it also shows everything I reposted, which counts as a post. I wish there was a third option for posts that I made that I created myself, because elsewise, if I repost 10 tweets, the thread that I'm looking for disappears. So what I'm going to do, it's up to you guys, right? We'll start with this. You guys want to hear me bitch about Pisco in a meta sense and the way he argues, or do you want to dive into the issue first? It's up to you. If we complain about Pisco first, it'll explain why it's difficult to piece everything together, but it's up to you all. If you're not interested in that conversation, we can skip that or save it for the end. Up to you all. So whatever people think. Do you want the conversation of me complaining about how bad faith Pisco is? And then we'll go from there to piecing together the specific argument on the case we've had? Or do you want to try to piece together the argument first? Let's see what the chat says. See if there's any votes in the chat. Issue? What? Was that an option? I assume you have Pisco, yeah. Yeah, I hear you now, Ian. Okay, so here's what I'll do. I'll start by saying this. This is very difficult to piece together because what Pisco does is, let's say I'm talking to Nico Pluto, and let's say I have a thread and I say, Trump is good. And then the way it normally works is Nico would say, Trump is bad underneath that. And then I would say, no, Trump is good because of XYZ. And then underneath that, he'd say, no, Trump is bad because XYZ. That would be the sort of conversation. What happens with Pisco is this. I'll say something. I'll say, I had a debate with Pisco and we argued about this and here's a bunch of things, blah, 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 blah. And then instead of responding, what he'll do is he quote tweets it. Sometimes not. Sometimes he tags me. Sometimes he doesn't. But he starts an entire new thread. And then what happens is when you have a detailed conversation, instead of it being person says something, response, 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 what it is I say something. Then his response is a different thread. Then I'll say a couple things there. Then he'll create a new thread. And so you end up with like 6 or 7 threads. Now, we'll skip the talking about him being bad faith. I only bring it up to let you know it is incredibly difficult then when you're going back to it days later to be like, well, what was said? What happened? I remember that he said this at this place and I can't find it. So we will be relying on sort of the thread that I created today, and then maybe I'll try to find some of his threads and see what my responses were on them. But that's the point. Now, I have theories. We'll skip why I think Pisco does that, but that's the gist of what's going on. Now, some of this I'll try to go to, believe it or not, I'm going to try, my computer, as soon as I went to X, started getting really loud. So I will show screenshots from X on the thread that I'm talking about, but I'm going to try to do it as, it is an incredibly slimy tech. That's why I said, should I start with that? Because it'll be difficult to explain because some of it you're going to have to take my word for it. Because it would literally take like 4 hours to go through okay, I know he said this here, so I got to go back. And that's why it's difficult because when I just go to my replies, some of them's on Pisco's thread and some of them are on mine. And I'll just show you real quick without going through the thread that much, what it ends up looking like the next day. This is sort of what it looks like on my feed, what ends up happening. Now you see this? When I click to notifications, I'll see this. Because we're having the argument in 3 separate places, it ends up just spamming. You'll answer one place and then just spam it. So this is what my feed ends up looking like, where it's like I'm trying to like hear what his argument is and respond. And it's just shit like that. It becomes very difficult. And then it looks like, let's say, Nico's watching my thread and Ian Novak's watching Pisco's thread and he's watching me and Pisco argue back and forth. Ian has no idea that I answered what Pisco's saying on this thread because I answered it over on this other thread. And so now I'm forced to spam that answer over here as well. And you end up, it's such a waste of time and energy just for him to be duplicitous. It's really annoying. It's just, even if you like Pisco and you think he's winning the argument against me, why do you do that shit? Now, I have my theories. I think he does it because it drives up his engagement, and because if his point is always the first post in a thread, more of his fans are always going to see it. You always see there's always more engagement on the first post than there is the subsequent. So if I have the first post and he's answering me, he's afraid I'll have more engagement. More people will see it. So he has to have that's, I think, what's going on. And it also makes it less likely that people that aren't his followers see what he's saying. And then the last thing is, like what he did today, once he was proven wrong, what he did today was he ended up just creating a new thread without tagging me. And was just like, Rob's so crazy and I blew him out and blah, blah, blah. Because then the people that just see his thread are like, oh, okay. And so then I'm not tagged, and the only reason I know and then got to go to that thread and respond to what he was saying was because someone else tagged me. But he didn't. And it's not the first time this shit's happened. It's another example of him being bad faith, that it makes it difficult to, I could talk all day what that means as far as him. But for the sake of this, I'm just saying it makes it very difficult when trying to have an argument. and keeping everything in order to know what was said where. And then what ends up happening is you're able to then later say, I didn't say that. I said this. This is what I meant. Here, see? And let's say we each had 50 posts discussing this over a span of 6 threads. He'll be able to say, see, on this thread, I said this. See? And it makes it difficult. And it actually, my advice to him would be, I could do the same thing then. It makes it difficult for him. If it was all in one place, then you'd be able to say, oh, okay, yeah, that is what you said. That's the chronological... I don't know. Anyways, that's sort of what I'm getting to. So, I'll explain the situation here. So, what had happened was, I did this panel. I've already admitted on here. I admitted in my conversations with Pisco that what happened was, I went on, said things, looked a little dumb, I'll admit, because I didn't understand the specific process. And I'll also admit this. I was unaware, fully admitting this, I was unaware that there were pretrial motions that outlined legal theories of what the unlawful act was, the unlawful means, right? So I didn't know that. Instead, now I don't blame me for not knowing that, because what I tried to do with this trial, because I couldn't watch it, I tried to make sure I was listening to people on both sides of the aisle. So what were they saying on MSNBC and CNN, and what were they saying? I don't listen to Fox, but like Jonathan Turley. Jonathan Turley, someone I consider sort of checks his bias a lot. He's a very smart dude. And I would say he's moderate, but probably leans right wing. I think that's a fair assessment of him. But I didn't just want to listen to him and Alan Dershowitz and people that I've heard criticize sort of lawfare before. I wanted to make sure that I was getting sort of an even space about it. And so, for example, 2 of the people that I heard was Dan Abrams, who I believe is the senior, but don't quote me on that, legal correspondent for ABC, and I can never pronounce this, Elie Honig, who's a guy, Elie, who is the senior legal correspondent at CNN. Now, I'd heard Elie Honig before. I didn't know his name, but once I saw his face, I recognized seeing clips of him before, talking about Trump being guilty in some of these other trials, and how he thought the other cases against Trump. So this is not someone that's carrying water for Trump. Dan Abrams from ABC, he was just viral the other day for arguing with Megyn Kelly about this. But both I'm listening to, because both of them, Honig really hates the case. And Dan Abrams, I think, probably thinks the case should stand, but he's talking about significant challenges that could be brought in appeals. And both of them mentioned that they didn't know the charge until closing statements. And they still don't really know what the underlying charge was. Now, just a brief overview if you're watching and you don't know what we're talking about. Basically, this is what occurred in this. Falsifying records is a misdemeanor in New York. The statute of limitations runs out in that, I believe it's 5 years. So these crimes that Trump's accused of occurred in 2016. So the statute of limitations are over. He can't be charged with a misdemeanor. However, there is a statute in New York law that says it's a felony to falsify records to conceal another crime. Now, this is important, and I got to credit, I've sort of figured this out on my own in the past 2 days looking into this, but I have to credit an ex-account named Shipwreck Crew who really outlined this on an article that he wrote on Substack. This is where everyone is going wrong with this case. Everybody's saying there were 3 options for what the other law was. The options were a tax fraud, federal election violations, FECA, and falsifying records. But that's not correct. That is not what actually happened. The falsified record felony says you had to falsify records in the commission of another crime, basically. And that other crime is 1715-2, which is basically conspiring to steal an election, to affect an election. A conspiracy to affect an election by using unlawful means. So you have the felony. In order for it to be a felony, you have to have the underlying crime, which is conspiracy to affect election. And in order for you to have conspiracy to affect election, there's a third level, which is what everyone's missing. There is a third level, which is the unlawful means. Right? So let me re-explain that. The felony falsifying records, Falsify records to conceal a crime. So it doesn't matter if records were falsified. That is irrelevant. What is relevant were records falsified to conceal another crime? Okay? So in order to charge this, you have to believe he's guilty of this as well. Okay, what's this? What's the underlying crime? The underlying crime is 1715-2, which is basically conspiracy to effect an election by unlawful means. So in order to believe that he committed this crime, you have to believe that he committed one of these three crimes. You see? So the base is you first have to prove that he committed one of these three underlying crimes. Then if you prove that, you have to prove that he committed that was enough for him to commit conspiracy to effect an election. Then if you prove that, you have to prove that he falsified records to do it. That's what's going on. There's that middle level, and it actually becomes important. Hopefully I'll get to that when we're debating Wednesday. Maybe we'll talk about it some tonight. I don't know. Not really relevant to what we're talking about with this thread that I'm going to go through. Now, one of the big issues that everyone's talking about is the judge told the jury they don't have to agree on what the unlawful means are. They do have to agree that he falsified records to conceal a crime. They do have to agree that that crime was the election interference. But they don't have to agree on what the unlawful means was that was done to commit the election interference. They don't have to agree on that. And that's very troubling. It's troubling because there are going to be appeals that say that that violates due process, that you have the right to know exactly what you're being charged and accused with. Here's an argument that people, and I've looked into this and this is accurate, there's going to be an appeal that the jury instructions did not tell the jury that he had to be guilty of the unlawful means beyond a reasonable doubt. They were never instructed of that. Never. They were instructed, had to be beyond a reasonable doubt when it came to the felony falsifying records. They were instructed it had to be beyond a reasonable doubt when it came to engaging in a conspiracy to affect the election. But they were not told that the unlawful means that was necessary had to be beyond a reasonable doubt. Another thing that's going to be a problem with this that would be something that you could appeal is, what if the three options that we're giving, the federal election violations, the tax violations, and the falsifying records, yes, that's how ridiculous this is. You can't charge Trump anymore for falsifying records in New York because it's a misdemeanor and the statute of limitations is out. But you could call it a felony if you say he falsified records to falsify records. Now it's a felony and you could charge it for 10 years, which is insane. But that's the theory, one of the theories they used. But let's say there's all three of those theories. We have no clue as of yet. I did not see anywhere, and maybe I'm wrong about this, I'm willing to, but from what I saw of what we could view of the ballots that were returned from the jury, I did not see, and nor have I heard anyone speak on this, in fact, quite to the opposite, that each jurist put what unlawful means crime they thought was committed. So we don't know. We have no clue. And even if they would all come out and say, this is what I thought the unlawful means was, that's not good enough. Because we don't know if they're changing their mind now. We don't know because they weren't forced to say, yes, this was the crime. The problem becomes, in addition to just general due process concerns, what if one of those unlawful means was overruled? For example, what if they say this, and this is going to get difficult. There is a solid argument to be had, and we'll talk about this later, hopefully, that, remember, the unlawful means, those three crimes, federal election violation, tax violation, and falsifying records, have to be done as an unlawful means to commit the federal election interference. Election interference. What if a judge or an appeals court would rule, actually, we don't think the tax count, the unlawful means, would be something that would affect an election, so we're not going to count it. That wasn't an unlawful means that they were able to use for Section 1752. Does everyone see what I'm saying? If an appeals court says, because remember, it's layers. Falsify the felony, falsify records to conceal a crime. Then there's the crime, 1715-2, the conspiracy to affect an election. That has to be done by unlawful means. One of those unlawful means is the tax records. Now, hilariously, I'm not making this up. This is the God's honest truth. The state's argument was Trump falsified tax records, which resulted in him paying more in taxes. No, jerk taker, I haven't seen it. You resend it to me, man. So Trump violated tax laws because he falsified records that resulted in him paying more in taxes. That's legitimately their argument. But let's say an appeals court would say, actually, we don't think everything else about the case is good, but we don't think the falsifying records to affect an election by unlawful means, we don't think that falsifying tax records or whatever, we don't think that meets it. We don't think that caused an effect to an outcome of the election. Qualifies for that crime. Now what? Because the defense is going to say, okay, well, how do we know? What if 4 people on the jury said, we think he's innocent of the underlying falsifying records charge, and we think he's innocent of the federal election charge, but we did think he committed the unlawful means of this tax charge. But now that that's thrown out, now what do you do? Well, that means he would have been not guilty because those 4 jurists would have said, oh, well, no, I don't think he committed those other 2 unlawful means. It's a nightmare. Why would a judge do this? Now, here's my God-honest opinion. My guess is all 12 of the jurists probably thought he was guilty of federal election violations. The FECA, federal election filings. So why wouldn't you just say you have to be unanimous on one of these 3 unlawful means? It solves that problem. But because this judge wanted to stack the deck as much as possible, they put this in. And I wouldn't be surprised if that's inevitably the issue that leads to it being appealed. Here's a conspiracy theory. I wouldn't even be surprised if the judge knew that. Because it's not really about this case standing. It's about affecting the election. That's what it's about. And so by the time all of that's litigated, it's already affected the election. The Democrats got what they wanted. Oh, you can't vote for a convicted felon. And if it gets overturned on a technicality like that, what do you think the Democrats' argument's going to be? Oh, he's still guilty. Oh, just some stupid technicality. He's still guilty. He still was a convicted felon. That's what they'll say. So instead of it being overturned on appeal because, no, you can't charge federal election laws as a state. No, this was selective prosecution. No, the evidentiary burden wasn't met. Instead, they'd be able to say, oh, it was because this one little issue. Oh, well, he's still guilty. Oh, well, it's over with now. That'll be the argument. Now, I got in the weeds there. That was stuff that I wanted to talk about later, but I ended up talking about it now. Anyways, all of that stuff more important than the discussion Pisco and I was having, which I foolishly waded into when I got on that panel, which was that Trump's team wasn't made aware of the charges until basically closing statements. That's not true. There were pretrial motions where the judge said which legal theories the prosecution was allowed to pursue regarding the unlawful means. And they outlined these 3 theories and they struck down one. Also, on May 21st, I forget what they call this, the jury chart or something like that, jury charges, they were outlined on the jury charges May 21st, but that was basically at the end of the trial. That was right before closing statements. Now, the argument why it would be a big deal, and this is why it piqued my interest and why everyone should be freaked out, is forget about arguments like due process, like the technical definitions and all that. Let's just talk without all the jargon. We should have a legal system where you're allowed to know what crime you're charged with. Right? Everyone could agree. And there's obviously all sorts of history to why that is important. The concept of due process. But that's basically what we're talking about. You go through a trial and you have no idea what you're being, like, just forget about the charge requiring an underlying charge requiring 3 underlying charges. Forget about that for a second. Let's just say you're charged with grand theft and they never tell you. And you're just sitting in court and they're like, yeah, we're going to, opening statements are like, this dude committed a serious crime. We're going to tell you all about it. Okay. And then your opening statement, you're going to be like, I have no idea what I did. I'm clueless. You can clearly see why that would be ridiculous. Just ridiculous, right? You have the right to know before the trial. You have the right to know during the trial what your charges are. You actually have a bunch more rights. You have the right to confront your accuser, to hear from your accuser. There's a lot of rights that you have, due process rights. And it makes sense. Now, I can't tell you the case law specifically or, from English common law, the specific tradition to come. I can't tell you all that. But that I know, and you know, and we know, and all the lawyers know. We know that. Now, there's questions of, well, what's the threshold of that? And that's where you start to get in the minutia. But in general, we have a system that prioritizes the defense. The advantages are supposed to be given to the defense because you would rather a guilty person be freed than an innocent person be jailed. That's the argument. So the defense is supposed to have, in a criminal case, supposed to have the advantage. So clearly, you should know exactly what charges you're facing. The other thing that's weird about New York is, and I don't know why this is the case, but the prosecution speaks last, which seems antithetical to the idea of prioritizing the defense. Because speaking last is a huge advantage. Fresh in the mind of the jury as they deliberate. You get to respond and have the final word. It's not hard to see why that's an advantage. So it's strange to me. I'm sure there's a reason in some New York law that says why in certain trials the prosecution speaks last. But whatever, it is what it is. So they get to speak first and last, which is an advantage in both senses. They gave the first opening statement and they gave the last closing statement. Whatever. We might disagree with that, but if that's not unique to Trump, if that's the way things are normally done, no, I don't think so, folks. I think in most states, the defense speaks last. Unless I'm mistaken, which I could be, but anyways, it's not really something that matters if that's just the way it is in New York. The problems become when it's things that are out of the ordinary. That's what it would become a problem, because then it looks like they're targeting Trump, which is selective prosecution. So when you talk about a novel legal theory that's never been used before, that's a problem. You're going to use that for the first time ever to go after a president? Shouldn't it be like a legal theory that we've heard dozens and dozens of times? Anyways, neither here nor there. So, that sounds like a big issue, because if that's true, if the prosecution never outlined what specific charge they were going for until literally their closing statement, that would mean that the defense never even once got a chance to speak up knowing what the charges would be. That would be insane. That would be insane. However, two things. One, they were aware of the jury charges before they gave their closing statement. I don't think that's sufficient. You should know what the charges are before closing statements. But it would be way worse if you didn't know about it until the prosecution's closing statement that would be last. So the whole trial, if you didn't know, and then you find out right at closing statements, even though you'd get to say in your closing statements, you wouldn't get to hear the prosecution's theory necessarily of why you broke those laws or those unlawful means and a chance to respond. The other time that they would have been heard was in the pretrial motions. There will be a debate as about whether or not that's sufficient. I feel, and I don't have case law or anything to back this up, if you have an indictment that doesn't say what the specific unlawful means are, and you have an opening statement that doesn't say what the unlawful means are in the trial, and then you have witness testimony and evidence phase, which doesn't say what the unlawful mean was, and then finally the first time in the trial that it's heard, is the jury charges right before closing statements. I think that that's a problem. Even if in pretrial motions, proposed legal theories that were allowed to be used were presented. And to me, that's the key difference that I think there's going to be argument over. Had the indictment said, this is exactly the charges we're going for, it wouldn't be as bad. I still think it's unusual, maybe not, but my understanding of this, and I have read several state laws on this, but even if it's not a law, it seems to me the opening statement of the prosecution should be for the intent of explaining an overview to the jury of exactly what crimes were committed and how. They're going to tell you a story. So they'll say, you'll hear from this witness that, Trump did this, and you'll hear this, and we'll provide bank statements that show this. That Donald Trump falsified records, and he did so to negatively affect the election through unlawful means, and those unlawful means were tax violations, federal election law, and then falsification of other documents. That's what I would expect the opening statement to be. They don't mention it once in the opening statement. Not once. They never mention what the unlawful means is. Not once. They don't mention it in the indictment. The only times it's mentioned is in this pretrial motion. And then in the jury charges and closing statement. So the entirety of the trial. And for me, it's like, I think there's a compelling argument to be had that the pretrial motion is outlining the theories that the prosecution can legally put forth. Because the judge is saying, this is what I'm allowing, this is what I'm not allowing. But I feel that it would behoove the court for fairness to, once the trial begins, at the onset of the trial, for the jury, but more importantly, for the defense to know the specific charges that the prosecution will be going for. Now, I will fully admit that I don't know that argument would win on appeal. This is not the best argument. Now we get to my argument with Pisco. The argument with Pisco is that he mocked me and said that it is so clear that this is how things are done in a normal trial. So I've set the stage, you see. And I want to be clear about this right out of the gate. This is not the most important argument. It's the one that we spent most of our time talking about when I called in, and I think that optically I lost. And I lost on specific details on this. I thought I did much better when we got to stuff I cared about more. But, absolutely correct that I did not have the full picture. Now, I think that it's reasonable for me to not have had the full picture because I at least did the due diligence of listening to commentators from all over the aisle that were saying, yeah, we don't even know what the specific charges are, even at the end. And there's a problem with that. That's where I didn't just pull it out of my ass. I wasn't just tuning into Steve Bannon and Steve Bannon said it and you could say, well, of course, he's going to defend Trump. I was trying my best to get a picture as wide as possible. But that doesn't excuse the fact that I was wrong, that it was mentioned in pretrial motions. Clear? We got that? Did we get that out of the way? It's okay. I can admit. No problem. I look bad optically. I was having even before, I will say this, a little in defense, I came off as way too shitty and pissy. But in my defense, I was shitty and pissy to the guy that called in before talking about immigration, which I shouldn't have been that shitty to him. So it wasn't like I was just shitty because it was Pisco and that panel. Who would my ideal partner be for Wednesday's debate? Jonathan Turley? Robert Barnes, Viva Frey? Maybe Good Logic? Like a lawyer? That would be my ideal partner for that. Steve Bannon. Anyways. So I just want to be clear. I do not think this is slam dunk. That I'm saying, yep, 100% in appeals, the court will definitely say, oh, no. You had to outline in the indictment or in opening statements exactly what the underlying charge was. I think that there's a chance that might lead to an appeal, and I certainly think, for me personally, that seems ridiculous. But just because it seems ridiculous to me doesn't mean that that's grounds for appeal or a due process violation. The argument I had with Pisco was him mocking me, which is fair, mocking me, not knowing, I forget what the pretrial motion, the exact word he had for it. I don't give a shit, it's pretrial motion. I didn't know the name of that. And I didn't know that this was said in the pretrial motions. And then he got me in some gotcha where I said, I thought that they were allowed to argue about the law, what the law says during the witness phase. No, that's just the judge's job. Which I knew it was the judge's job to instruct the jury of exactly what the law said. But I thought that, which is what the argument was, you're allowed to bring experts in to say this is exactly what this law means. And the other side would say, no, we think it means exactly this. And then the judge would give the instructions. That's what I thought. They were allowed to argue in that level. Turns out, sometimes judges allow that sort of stuff, many times not. So it's fair for him to mock me in that. But what he was quite specific on was in regards to the trial not even mentioning what the charges are until closing statements. But the pretrial motion, not the indictment, the pretrial motion mentioned it. He said that was normal. And he basically implied anyone with a cursory knowledge of trials would know that. That's the debate. That's the argument. Because I then would go on to create a thread, which then, of course, caused Pisco to create different threads, based on the argument of that idea. The idea that this was normal. That's the way things are done normally. And this is important, this part of it. Anyone with a knowledge of trials would know this. It's so evident. For example, it's so evident, it's like the judge gives jury instructions. And if I said, no, the judge doesn't give jury instructions, or, it has to be 12-0 to get a conviction on this sort of felony. And if I said, no, it doesn't, Pisco could rightfully mock me and say, you didn't know that? You didn't know it had to be 12-0? You probably don't know what you're talking. Anyone with a cursory knowledge would know that. So certainly if you've passed the bar and you're a lawyer or you're a legal analyst, you would know that. So that's the argument. That's what Pisco's saying. Which led to me to create a thread that showed Dan Abrams and Elie Honig from ABC, senior legal correspondent Dan Abrams and Elie Honig, both of them saying that it was a problem that they didn't know the specific charges until closing statements. And they still basically don't know exactly what's being alleged. My contention was, in the creation of my thread, if Pisco's right, that this is something that's so normal and so evident that anyone with a cursory knowledge of the law would understand it, why are legal experts from major networks who don't like Trump saying there's a problem with this? That's my argument. Now, this is meta. Again, because the argument boils down to an argument about an argument that isn't the most important argument in the trial. But that's what I posted. It could have ended him just being like, well, okay, sure, they said that. I guess there's disagreement. Whatever. That could have ended the argument. But no, that's not what happened. Now, there's confusion between the interactions and Pisco and me have. I realized today what some of this confusion is. He kept saying to me, show me when they're saying that legal theory should be discussed in front of the jury. But I said charges. Now, it is true, and I admitted this, that on the panel that I called in, I did make the argument that I thought that the charges should be discussed in the trial. That even if they were discussed previously, I thought that the jury had the right to hear him during the trial, not just closing statements, and the defense had the right to respond to them. That still may be the case. It may be. However, I will concede that I don't think that's what Honig's saying. Now, having said that, Honig is definitely saying he saw a problem with three things. Pretrial, the non-specificity of the charges, specifically not including them in the indictment. That's number one. Thank you, Randy West. I appreciate it. Secondly, during the trial, that the specific underlying charges were not brought up until basically closing arguments. He says that quite clearly. And third, that the judge, and this is how he puts it, and maybe I'll find these clips and I'll show you. He says he was shocked that it was inverse of usual, basically, that the defense was begging the judge to instruct the jury on the specifics of what the underlying charges were, but the prosecution was begging the judge to be as vague as possible, which the judge was. That he also has a problem with. So three things. Non-specificity of the underlying charge or the unlawful means pre-trial. Non-specificity in outlining them during the trial until near closing statements. And third, the judge not specifying and giving this sort of buffet of options in the jury instructions. The theme running through all those, and someone tell me if I'm wrong, the theme running through all of those is the idea of the defense deserves due process to know specifically what the charges are. So there is a question of whether or not Honig would agree with this statement. If the indictment specifically outlined exactly what the unlawful means were, but during the trial, the prosecution never brought it up in opening statements, didn't bring it up through witness testimony, and only brought it up in closing statements, would Honig have a problem with that? Would he think that's a due process violation? I don't know. What Honig's saying is, it's really bad that they didn't do what they were supposed to pre-trial. They violated due process. And it's even worse then that come the trial, they still didn't do it. And it's even worse when you factor on that the judge's jury instructions were as vague as possible and gave them three separate options that didn't have to be unanimous. That's his argument. Now, that would seem to suggest to me, and you tell me if this is a fair statement. Anyone in the chat, give me a yes or a no. Ready? If I'm accurate about what Honig said here, and I'm not asking you to trust right now that that's what he said, but if I'm accurate, Pisco's statement that this was so obvious, the normal procedure of how it goes, that anyone with a cursory knowledge of the law would know, seems to be a bullshit statement. Right? If there are legal experts who you can't really say, well, they're biased for Trump. Senior legal correspondents for major networks that are saying this is a problem, then it doesn't seem like that's normal. If it was normal, they would say, of course, there's no problem. No one would have a problem. Everyone would say, right? There isn't any legal expert standing up going, my God, it's an outrage that there were 12 people on this jury. Why? Well, because it's normal. There's 12 people in a jury. That's normal. So for a legal expert, multiple of them, and that's just those from networks that don't like Trump. You have Jonathan Turley, Alan Dershowitz, a host of other legal scholars, all over the place that are like, yeah, but Pisco's saying, no, this is normal. This is how it's done. Everyone agree that that would mean that he was full of shit. And the problem is, it's particularly a duplicitous tactic because what happens is when you have expertise in something, particularly when you're debating someone who's fully admitting to you, yeah, I'm not a lawyer, it's true, you can abuse that by misleading people into how the process goes. For example, as I mentioned on my live stream yesterday, I believe, I could bullshit you what an average policy debate round looks like. You might have a legitimate criticism. And I'd say, no, that's normal. That's how it goes. How would you know? You'd be like, oh, okay. But if a bunch of other people who have more accolades than me in policy debate go, no, Rob's full of shit, that's not normal, you might say, oh. And so the argument then becomes to Pisco as follows. Okay, so if you're right that this is a normal procedure, that anyone with a curse or normal way things go regarding the specificity of the charges only being announced in pretrial motions and basically closing statements, if that's normal, then how are these legal experts from major networks that don't like Trump saying this? There's only two options. This is what Pisco says. Well, it's because they didn't know about the pretrial motion. That's why. They didn't know about the pretrial motion. Then the problem becomes this. Let's assume Pisco's right. That the senior correspondent for CNN and the senior correspondent for ABC, in probably the biggest trial that they've ever covered, like this is their Super Bowl, they went on national television and said something that is obvious. Most trials, the normal course of a trial, they don't outline the specific charges, and the way you know them is to go to the pretrial motion. And yet, in this, their Super Bowl, they didn't do that. They were just, through laziness, there's only two explanations. Either they are incredibly lazy, that they knew they were supposed to look for the pretrial motions and didn't, or they're incompetent. They don't know the first thing about the law because they didn't know that they should be looking towards the pretrial motions. That's it. That's the only two options if Pisco's right. The third option is Pisco's full of shit. That's the three options. Either Pisco's right, that this is the normal way things go, which means, and it's obvious, it's so obvious, you could laugh at people that don't know this. And so that means either they didn't look and they knew they should have, which means that in the biggest trial of their life, in the biggest day of their jobs, they just were lazy, which means you should never trust them for anything, if that's how bad they are. Or they didn't know, which means they're as incompetent as the average person like me. Now, I know what my money's on. Do you think Elie Honig, senior correspondent at CNN, and Dan Abrams, senior correspondent at ABC, and Jonathan Turley, and Alan Dershowitz, do you think they're correct? Or do you think they are all incompetent rubes and Pisco, who does like to put his expertise over me, which absolutely is true. I believe he's passed the bar. I believe that's true. I have not. But I'm willing to bet, as much as Pisco has expertise in a technical aspect in the law over me, my guess is that expertise falls far short of the names I just mentioned. That's my guess. So if I have to pick between, and I'm not saying an argument, if Pisco and Elie Honig get into a debate on panel about specifically a charge or something, that's one thing. But that's not what Pisco's saying. He's saying this is obvious. It's not even debatable. It's just obvious. It's obvious. It's so obvious. That's what he told the audience. That's what he told the panel. Oh, you got blown the fuck out. It's so obvious. Rob looks so dumb. Okay. So there's no debate. So if you're right, then these people are fucking idiots. All of these legal experts. So that's what I asked him. Which one is it then, Pisco? And that's what started this big exchange that went to thread to thread to thread to thread to thread. Now, during this exchange, one of the things that kept occurring was he kept asking me to show them saying that legal theories should be presented to the jury before. And I'll admit to misunderstanding what he was saying, because what I said was charges should be presented. Now, it's clear, and I'll show you with receipts, that I continually clarify, that the problem is the defense not knowing the charges. That's the problem. It is true that there is a question, and I did say at one point that they have the right, even if it was in the indictment, to hear those charges during the trial, before the closing statements. I could be wrong about that. I still think it would make sense to hear the charges in the opening statements, because you should be allowed to rebut that instead of guessing it. Because they could theoretically only go for one charge at the end of the 3. Oh, is that what he said? Pisco said I'd be bad faith. He has no intent. Let's see. That's great. That's great. Let's see the tweet. This is good stuff. Huh? Oh, damn it. Getting this. There we go. He says, as an example of your terrible manner and why I have no interest whatsoever in going on your show as a guest, see the title of your stream. Putting my profession lawyer in scare quotes implying I'm a fraud. I would have never attacked your profession. Only he says, now busy for the next hour in any event, not inclined to slightest to cede muting privileges, a power you have abusing. If you want an example of discussion, what you're incapable of, see my interaction with Good Logic last night. Right. Coward. Now maybe he is busy, but coward. So, that's how we get here. So we go back and forth. I'm like, which one do you think it is? It's like I was saying, I admitted, and I still think, and it is a question. For example, I did find, I'm not going to bring it up now, but I did find, for example, in North Carolina, it seems to imply that the charges must be read in the opening statement in North Carolina. I could not find that for New York, nor could I find that. I don't know exactly where to look. I've seemed to have found some things that says that an omit... that's different, yeah. So, but again, could be wrong, and I fully admitted that. But I kept clarifying that the problem they were outlining was my guess was they were aware of the pretrial motions and didn't think that was sufficient. They still said, no, that's not enough. If it's not in the indictment and it's not in the opening statement, it's in a not-door witness testimony and we don't hear about it until almost the closing, that's a problem. And then there's this separate problem, which Pisco admits is likely to be a possible appeal. The separate problem of the judge never told them specifically they had to be unanimous on an unlawful means. And yes, Honig has that problem as well. But he still has this problem. And Pisco was quite clear that he was like, no, Honig made a mistake. He made a mistake. He didn't read. That's what was going on. He didn't know about the pretrial motions. So late last night, after we're going back and forth in multiple threads, I specifically said, look, this is what's going on. I also said at about 8:30 last night, basically what I told you here. I'll fully concede that I said things on that panel. I was clunky with my language. There is a question of whether or not it has to be brought up in the trial or not to me, but that could be incorrect. I could be wrong about that. However, it's clear that my main point is this. Honig seeming to suggest that there's a possible due process violation because there was never sufficient informing of the defense of what the charges against were them until basically the jury instruction or the jury charges. And even then, the judge wasn't specific about it. So there's a problem in the way it was done. That's the problem. I was quite clear. And it was quite clear that Pisco was saying, no, Honig is saying, or Honig never saw the pretrial motions. That's what he's saying. In other words, once Honig was informed, oh, excuse me, sir, actually there's these pretrial motions that outline, he would say, my mistake. Never mind, I was wrong. You're right, the trial was... I was unaware of those, I'm sorry. And I said to Pisco last night in my last post to him, I said, we'll probably find out. It's Sunday, which probably people are taking off work. Tomorrow, he'll probably be working. He'll probably be on CNN. Maybe he'll be on X. And he'll say, okay. Because at that point, surely, because Pisco's showing me other people that are tweeting at Elie Honig, including Pisco tweeted at Elie Honig, and said, did you know about the pretrial motions? You're wrong about what you said about not being informed because of the pretrial motions. And I said, okay, so either we'll see Elie Honig say, you're right, I was wrong, I didn't know about it, or he'll say, no, I know about those, but still there's a problem. And if he says, but still there's a problem, that means Pisco's full of shit when he said that it was so obvious that anyone in the legal field would know this. That's what it would mean. And so would you be shocked to learn that Elie Honig spoke up today? Would you be shocked to learn that? And you're not going to believe this. You ready for this? But he actually responded directly to someone making the exact argument as Pisco. That said, hey, the pretrial motions solve everything you're talking about. And what do you think Elie Honig said? Do you think he said, like Pisco thought he would? Oh, yeah, okay. My bad, I didn't know about that. That changes things. You think he said that? No, he didn't. You know what he said? He said, it's clear what I was talking about wasn't that they said it somewhere in some motion. It was that it wasn't in the indictment. Which is almost verbatim what I said I suspected he would say. So then, when I posted, I literally told Pisco, he's probably going to say that it's too vague, that it should be in the indictment or something, but we'll see when he speaks up. So he spoke up. He said what I said he was likely to say. I show Pisco. Do you think Pisco said, you're right, I'm wrong? You were right, I was wrong. I still do. Now, let's be fair to Pisco. He could have said, wow, okay, maybe Elie Honig is a hack. Or Elie Honig's a hack. He's a fucking idiot. He doesn't know anything. I still disagree with him. Which he sort of says. He says he disagrees with him. But okay, you were right. That's what he said. Of course not. Of course he couldn't say it. Instead, he had to be like, aha, this proves you were wrong, Rob. How so? Well, because you said that he said that it would have to be that the jury needed to hear legal theories during the trial. Which again, I did blurt that out on the panel. But I clarified, to which Pisco saw, blatantly, that's not what I'm talking about. I'm clearly saying that Elie Honig saying there's a problem with due process, that there wasn't sufficient information given to the defense pre-trial, and there wasn't sufficient given during the trial, and he didn't like the way that the judge handled the jury instructions. That's what he's saying. Now, let's say Pisco's right for a second. Let's say that Pisco's... Now, by the way, it does not. Elie Honig, because he's only responding in one post on X. So he's not saying this is everything I had a problem with. He's just responding to this one point of, oh, you said it wasn't said pre-trial, but here's these motions. And he's like, no, it's clear I meant the indictment. He could still believe, look, I think it's a problem and possible grounds for appeal, even if it was in the indictment that it wasn't brought up in the trial. He may believe that. He may not. But it doesn't disprove. Pisco trying to say, oh, he clearly says that if it was in the indictment, that would have been it. No, he doesn't. That's not what he's saying. He's responding to a specific post. But I even give Pisco an out on his thread, I think, which I don't know if I could find this. And the out is that I give him, which, by the way, I almost guarantee he's listening. Almost guarantee it. But the out I give him is simple, which is, okay, man, can you at least admit you were wrong when you implied that he wouldn't read it? He hadn't read it. No, he can't do that. That wasn't the topic. Can you at least admit I was right when I said he's probably going to say that it wasn't in the indictment? Can't do that. Can't do it. And that's exactly what I'm talking about. Now, this illustrates two things. There's the general thing that it illustrates, which is how people abuse their position, like this, abuse this appeal to authority. And you see this more generally when people are like, trust the science. That guy's a scientist. You're not. You clearly don't know what you're talking about. Or you can see it in more specific ways, like when you debate an economist, and the economist is going to have a better language set to talk about specific problems in you. And he might have specific statistics and stuff. So it could be difficult, for example, if you're debating an economist, and I thought, this is why I was unimpressed with Noah Smith. I thought he would be better when I debated him at this shit. He was pretty bad, I thought. I wasn't impressed at all. He certainly sucked ass on every topic that wasn't the economy, but he didn't do so hot in the economy topic as well. Right? But nonetheless, the way it works is you could take the Great Depression and you'd be like, wow, this economy sucks. And they'd be able to be like, no, if you look at these numbers and look at these and look at these and look at these. And someone listening might go, oh, that sounds persuasive. I wish I could afford bread. Same thing with the legal profession. You're right. I don't know the specifics, the names of, all the types of motions. I don't even know what's normal. I have a general idea of what's normal, and I have concepts that I think of what the purpose of it is, and sort of what the norms should be. You have the right to know what the charges are against you. You have the right to respond to them. Right? You have the right to non-selective prosecution. It doesn't matter if I can cite case law. These are concepts that we can understand. So it seems to me that the entire idea of Rob, you're such an idiot because I'm literally reading from legal analysts from major networks that don't like Trump that are saying this is a problem is nonsensical. But it's appealing to an audience that'll be like, yeah! So let's go to the if I can find it. Oops, wrong button. Let me find it first, I guess. Let's go to some of these threads. All right. You can hear my computer overheat and just go into X, so I'll try to be quick while I'm on here. I say, update to a thread from yesterday. Pisco Liddy mocked me in a panel a few days ago for saying there was a problem with Trump not knowing the specific underlying crime that Trump was charged with until near closing arguments. He said that's totally normal during the trial, and the pretrial motions included the specific charges. I claimed I admit I'm not a lawyer, but if it's so normal, why are senior legal analysts that don't like Trump, like CNN's Elie Honig, claiming they have a problem with it? Were they to be mocked too? I also said it seemed like that they had a problem with what happened in the trial, and I felt the defense had a right to know the specific underlying crime during the main portion of the trial. Pisco said clearly Honig just wasn't aware of the pretrial motions, and if he was, he wouldn't have made the claim that Trump's team wasn't properly informed before the trial. He also claimed I had no proof Honig said anything about the charges being known during the trial. I showed him two videos, which we'll see if I can bring up later. I showed him two videos of Honig, one where he says he was shocked that the judge didn't force the prosecution to commit to the specific underlying crime until near closing arguments, and one where he said he was shocked that it strained due process that the prosecution asked the judge to be vague in his jury instructions while the defense pleaded for him to be specific. So Pisco was wrong on that aspect, and it seems Honig disagreed with Pisco that this is how a trial is normally done. Nonetheless, Pisco maintained Honig only said these things because he wasn't aware of the pretrial motions outlining the legal theories. He even posted to Honig's X account asking for clarification. And lo and behold, Honig answered another person with the exact same point. And wouldn't you know it, just as predicted, Pisco, the great lawyer who mocked me, was completely wrong and I was completely right. How can that be? Pisco was so confident mocking me, telling me to take the L. Remember, the next time Pisco touts his legal credentials, he may know the jargon and he may sound competent, but he's a bad faith partisan hack. Here's Elie Honig's post today. This is what he's responding to. From Ryan Goodman at Good Law. He says, Elie, inexcusably the DA refused to specify what those unlawful means actually were, and the judge declined to force them to pony up until right before closing arguments. Middle, November DA motion specifying the three means. Right. February 24th, ruling in favor. Here's the quote that you can see, and he highlights the portion. Inexcusably, the DA refused to specify what those unlawful means actually were, and the judge declined to force them to pony up until right before closing arguments. So much for the constitutional obligation to provide notice to the defendant of the charges against him in advance of the trial. This, folks, is what indictments are for. Now, this clearly shows two things. One, he is saying pre-trial that there wasn't enough specificity. He's also saying that the DA didn't specify until closing, and the judge didn't really make them until near closing. So he's making both arguments. Now, I think he's connecting them. He's saying it's a problem They should have known pre-trial, and not only did they not know pre-trial, they didn't know for the bulk of the trial. That's what he's saying. He says, for your consideration. Oh, I'm sorry, no. I say, are you saying the third picture listed in that thread? Never mind. That's a different argument. Okay? Here's Elie Honig's response. Quote. This is from this morning. I truly like you, Ryan, and respect your scholarly work tremendously, but this is a sloppy gotcha that is unfair and betrays a lack of actual criminal experience. You highlight one sentence of my piece, obscuring the next two sentences, which make it clear that I mean, notice, by indictment. So they weren't informed pre-trial by indictment. Then he says, which, as any criminal practitioner knows, is constitutionally and practically quite different than, quote, mentioned at some point. I trust you'll get back to your excellent scholarly work. In other words, Pisco's theory that, no. Honig just didn't read the pretrial motions could not be more clearly rebuked by Honig. He says, no, I wasn't talking about pretrial motions. Even with those, no. I'm still saying there was a problem. Pisco said it's totally normal, and every legal scholar would agree. Anyone with a cursory knowledge would understand that's totally normal. Clearly not. Now, that means, at this point, Pisco's only two excuses were he was unaware of them. Even if you want to argue he could have been unaware of the pretrial motions when he wrote his article that was quoted there, he's certainly aware now, and he's saying they're still not sufficient. Which leads us to the only other possibility, that if it's true that anyone with a cursory knowledge of the legal system would know that this is absolutely the normal way to do things, then Elie Honig is an imbecile and totally incompetent and should never be trusted on anything else. Right? Because Pisco didn't say like, yeah, there's dispute, there's disagreement, but I ultimately think they're wrong. He said, you'd have to be an idiot. So that should surely be the case, right? Is he bought and paid for by Trump? Is he completely incompetent? What's the story? Then we'll continue on my thread. As a brief follow-up, it's hard to find our entire conversation and ask. Never mind. But I already talked about that. We don't need. Pisco doesn't answer on the thread. He quote tweets. Now, I just want to be clear. When Pisco's, we'll go through some of this. Keep in mind when Pisco's like, I'm not going to come on your show because you put the name lawyer in quotes. I would never do that to you. Pisco in our whole discussions pasting gifs of me being like copium, of like Pepe the Frog doing copium. He's laughing at me, calling me a fucking idiot on the panel we were on, and well, I don't know the exact words he used, but he's mocking me. That's fine. No hard feeling. Like, I'm not, oh my God, how dare you do that? That's not what I'm saying. But you see how he gets butthurt? Hey, it's not like he was like, Rob, let me explain, I understand you're having some points and I can understand the confusion. That's not what's happening. It's debate bro shit. He's being snarky with me, I'm being snarky with him. But quotation marks in the title of this video is too much for him? Fuck you, crybaby. Yeah, that's what he said. Yeah, how dare you insult me and my profession? And he was saying about how mad I was earlier. Does that sound like a guy? He's coping. Hey, Pisco, I know you're probably watching. Ah, crap. I screwed up and didn't link. See, this is a problem. So here, let me show you. This is what I'm talking about. Instead of him just answering, I forgot to link his thread answering on my thread. So here I make the post on my thread. Then he quote tweets it and answers on a different thread. And I say, look at the copium. And what's he referencing here is a question I asked Good Logic about a hypothetical that in this trial, if there were no pretrial motions outlining the theory, that would be an obvious due process violation because Pisco said he wasn't sure. And that this is a separate argument. Pisco insulting my lack of knowledge of the legal system. I asked Pisco, I said, okay, because you're trying to get a baseline, right? We're going to have an argument, and this is something that you often should do in debates. If you think you're debating someone good faith, which unfortunately Pisco is not good faith, as I've shown over and over again. But what you want to do is get certain agreements on the scope of what you're talking about, right? So I'm trying to find a baseline for when Pisco would say, okay, that would be a due process violation. So he's saying this isn't a due process violation because it was listed in the pretrial motions. I say, okay, what if it wasn't? What if Trump walks into the trial and he's never been informed of what the unlawful means was? So in other words, he's being charged with a crime that in order to be charged for, he had to commit a crime. And that secondary crime, in order to be charged with it, he had to commit a third crime. But he's not being told what the third crimes are. So he doesn't know what he's being charged with. That seems to go against the Sixth Amendment and due process, right? And I expected Pisco to go, sure, if he would have never been informed, that would be bad, but that's not the case here. But instead, Pisco goes, I don't know. Really? You don't know? Now, maybe I'm wrong, but just as a layman, it's like, that sounds like a really bad legal take. You don't know? So I tagged lawyers like Viva Frey, Robert Bronze, and Good Logic answered on his show last night, but he screwed it up. And I don't mean he screwed it up like he said something that I don't like. He didn't understand it was a hypothetical. His answer was basically, oh, but they did. They did it in the jury charges, it said. So, but he didn't understand the hypothetical. But that was his response to me, and I'll see if I can find it. Instead of responding substantively, he was like, oh, you got blown out by Good Logic. And we'll find it. Oh, here's more Pisco from just a few minutes ago, which he's no doubt watching. The logs, tweets, and videos speak for themselves. I was completely correct, and you were completely incorrect. He was completely correct. Because you can't handle that, you go personal. He went personal with me when we were on the video. In fairness, I was personal to him when we were on that panel. That's just your personality. And it's the same whether you're beating inferior debaters or getting crushed by me. I don't think I've ever been crushed by Pisco in a debate. Here's where Pisco admits. See, look, this was before I put lawyer in hypotheticals, or in quotations. Does that look like a guy? I'm not insulting you. Does that look like a guy? Admitting that Good Logic, I said, I don't think Good Logic addressed our hypothetical. He said, no, he doesn't address the hypothetical that's irrelevant to the Trump case, where no one ever tells the defense about the theories of unlawful means. He does address what actually happened. Right. So then, his argument that Good Logic showed how stupid I was. And this is what I was responding. I know you're upset by getting bodied by Good Logic, but doubling down on your obvious error is not a good look. Which is what I was responding to. This is what he says. So desperate for a W that you are reposting Honig's deceptive response, which taken at face value crushes your argument. You said Honig was not referencing pre-trial, but the right to hear in trial. Honig says he's only talking about the indictment. That's exclusive pre-trial. And here's what he links to me. Did you read the exchange? The point is outlining the crimes pre-trial is not what Honig and Abrams are referencing. They're talking about the right to hear the charges in trial. Now, admittedly... Oh, sorry. Can you see that? Yeah, okay. What we're talking about here is video of Abram talking specifically about during the trial they didn't hear the charges. That is specifically what they're talking about in the videos that I'm referencing. And let's see if I can find that video. Let's close some of these windows. Again, this is all the more difficult because classic Pisco, he decides instead of responding in thread, he quote tweets all the time. So you got to look through 50 effing threads to find out. I'll find the one with Dan Abrams because I know I can find it quick. Again, this is Dan Abrams, who just the other day went viral for arguing with Megyn Kelly, talking about possible appeals. This is the video I'm talking about when I said it's clear he's talking not about pretrial, but during the trial. Oops.
But on the second question of the jury instructions, yeah, there's some real appellate issues here that are serious questions about why didn't the defense even know what the charge was that they were going to be applying, what law that was going to be applying.
Which of these three underlying laws?
Exactly. And so there were a lot of questions for the defense going into this, I think, as they were making their closing arguments, not even knowing sort of what the law that they were going to be battling over was. But on the second...
Let me play that again. You tell me, is he saying just pre-trial here? Is that what he's saying? Now, when I'm responding, I'm not saying that they're saying, that Abrams or Honig are saying, had they known pre-trial exactly what the charges were going to be, they would still make this argument during the trial. So there is a little bit of confusion. What I'm saying is, I hear them saying, no, they're only talking about problems pre-trial. There was no problems during the trial. To which my response is, they're clearly talking about during the trial. Right? Again, let's look at what I said, and then listen to Dan Abrams again. Did you read the exchange? The point is the outlining of the crimes pre-trial is not what Honig and Abrams are referencing. They're talking about the right to hear the charges in trial. Now, I'll admit fully that that is not the best way to word that. But they're clearly saying they didn't know the charges during the trial. And the point I'm trying to make is the fucking defense has the right when they're up there speaking to know what the charges are. They didn't know. That's the argument that they seem to be making. I'm assuming, maybe falsely, that when they're talking about, oh, no, they're just talking about pre-trial. I assume that they're saying like, oh, they're saying it's a problem if they didn't know pre-trial, but they're not talking about specifically how the trial was put on. Remember, my argument that I'm making is against the argument that Pisco's laughing at me because this is clearly how it's normally done. They don't talk about the charges during the trial. Instead, you have to go to the pre-trial motions. That's what I'm talking about. So listen, look again. They're talking about during the trial.
Question of the jury instructions, yeah, there's some real appellate issues here that are serious questions about why didn't the defense even know what the charge was that they were going to be applying, what law that was going to be applying.
Which of these three underlying laws?
Exactly. And so there were a lot of questions for the defense going into this, I think, as they were making their closing arguments, not even knowing sort of what the law that they were going to be battling over was.
Now, I'll admit, on the scale of posting on X, sometimes it doesn't come off as clear. What I assume that he's basically making as a general argument here is that he was aware of the pretrial motions. And I don't know exactly, I'll claim ignorance on this, I don't know exactly how this works usually. Are pretrial motions that something you commonly look at and go, yep, that's the exact charge, that's what's going to be talked about? Or are pretrial motions more, these specific ones, more something that you look at, here are the potential theories they could go for. And so in that case, Abrams would be saying, yeah, I'm aware that pre-trial, there were all these theories that the judge said, these are the acceptable theories they could discuss, but it was never specified which ones they would be going for in the trial. They never said it. That's what I'm saying when I'm saying they had the right to hear the charges in the trial. If they say, here's potentially the 15 things we could go after you for, not in the indictment, but just the judge saying, yeah, here's the 15 things we allow you to go. You don't know with specificity what they're going to charge you with in the trial. That's what I'm saying. And that's clearly what... Does anyone dispute that seems to be what Dan Abrams is saying here? Now, I'll try to find the Elie Honig clips. Again, I can't stress enough how aggravating it is that Pisco quote tweets everything, so instead of everything being conveniently on one thread, one response after another, I have to scour through multiple threads to be able to find this. But nonetheless, let us attempt. This might be the thread. Okay, here's one of them. As you listen to this, is Honig only talking about pretrial?
A big thing that happened today that was not as insane as Robert Costello's testimony, but maybe more important, was what the instructions are actually going to be from the judge when he speaks to the jury next week. I mean, can you just put it, it's basically telling this jury in, non-legal terms what the statutes are and what they're making their judgments based off of.
Yeah, so the jury instructions are so important. They're sort of dry, but they're crucial. They're the last thing the jury will hear before they disappear into that jury room to deliberate. And we, as a criminal justice system, we do the best we can. We try to have the judge explain it in non-legal, understandable terms. Some part of the jury instruction is easy to understand. For example, it's up to you, the jury, to assess the credibility of the witnesses. Anyone can understand that. Other parts get really deep into the weeds, usually when we get into the elements of the crime. And what happened today, when the parties were arguing about what the jury instruction should be and should not be, absolutely blew my mind. I need to call this out. We collectively, prosecutors, are pushing the boundaries of due process here. The general back and forth in the courtroom today was the defense lawyers saying, Your Honor, please tell the jury specifically what the other crime is, right? Prosecutors have to prove falsified records for another crime. Defense lawyers were begging him. They have to know what the other crime is. And prosecutors were saying, no, let's keep it very vague and general. It's a bizarro world. I know that there is some aggressive reading of the New York statute that says, well, the jury doesn't really have to know what the other crime is. But to me, that suggests that the DA's office is hell-bent on getting the conviction now and worry about the fallout.
Now, does that sound like he was just talking pre-trial, like Pisco said? No. Again, three separate arguments Honig's making. One, the problem's pre-trial, not informing with specificity the charges. Two, the problems during the trial, which I'll find the video on that. And three, the problems during jury instructions. Now, Pisco will say, yeah, I knew he talked about the jury instructions, but that still doesn't respond to the fact that he was talking about the problem with the charges not being known during the trial. Now, I agree that it's a direct line through him saying they never specified before the trial and they didn't specify during the trial. But when I'm saying, and I understand how Pisco, theoretically, if I want to attach good faith to him, which I'm reticent to do, I understand how he could read some of the things I was saying initially and say, oh, you're saying, Honig's saying, even if the indictment would have listed the specific charges, the charges have to be read during the trial before closing statements, which is not the argument I intended to make, as you'll see me clarify even last night. What I'm saying, and there's a miscommunication between, because Pisco keeps saying, tell me when they have to say legal theories. I'm like, what are you talking about? I said the defense has the right to know the fucking charges during the trial. The other thing to remember is Pisco's going to say, but that's just his problem with jury instructions. But see how he says the prosecution wanted them to be as vague as possible? Clearly he's implying the prosecution, up until that point, had been as vague as possible. Which again is a problem that he's going to outline. Remember, 3 problems. Problem 1, pre-trial. Problem 2, during trial. Problem 3, jury instructions. And you can see, he says, Rob doesn't seem to understand the jury's instructed on the law by the one and only person, the judge. He wants Trump to have been able to get a witness to go before the jury and make arguments. That's not the argument I'm making. I say again, you ignore the point of my post. How is this so obvious? And yet a senior legal analyst who doesn't like Trump can't see it. Surely every lawyer in America would be laughing at him. Again, I apologize for the fact that it takes me a while to find this stuff because it's on 50 different threads. Here's another point I want to make. If Pisco's right, as you'll see him say, we weren't arguing about why Honig thinks what he thinks. Why did he actually tweet this to Elie Honig? Long-time listener here, can you please clarify when you made this attached statement regarding notice, were you aware of the pretrial motion practice and the order limited to 3 theories of unlawful means? Now, Pisco's going to later say that wasn't our argument. Then why did he message Elie Honig to see what he meant on it? Just on a whim? In the middle of our argument? Here it is.
I want to go into the weeds. Hear from the jury privately by text. I was saying to you, hey, Elie, have you seen the verdict slip? Can you decided? Okay.
All right. Now, remember, Pisco's saying that Honig's statement crushes me that he made today. Because it was only talking about pre-trial motions and rather what should have occurred pre-trial. Now, I already played you the clip of him complaining about the jury instructions. Listen to what he says here on Smear Connish. This, by the way, was after the verdict. This was a day after people were putting the pre-trial motions out there saying Elie Honig was wrong. And this is what he says.
In the last couple of days, privately by text, I was saying to you, hey, Elie, have you seen the verdict slip? Can you flip it to me? Because I wanted to see what level of detail they were going to have to provide. You're the expert when it comes to matters of prosecution. Do you agree with me that this is a legitimate appellate issue for Trump? He can put it in the way that I put it. I don't know for what I was convicted.
They don't know what he was convicted. That sounds to me like throughout the whole course of the trial, he's not sure what the specific underlying charge was. That's what it sounds like to me. And of course, they're also talking about the jury instructions. Now that's smear Conish, right? This is Elie Honig that's about to talk.
There are two appellate issues here. The first one is what you said. Look, a basic fundamental principle of our criminal law process, of our Constitution, is a defendant is entitled to notice in advance of trial with specificity what he's being charged for, what he's being tried for. That's why we have indictments. Now, the indictment in this case does not specify what the underlying quote-unquote unlawful means are. And in fact, and I found this to be shocking, frankly, the judge did not make the prosecutors commit to any of those unlawful means until we were just about into closing arguments.
Did you hear that? He says the indictment didn't have it pre-trial, and in fact, the judge didn't even make them begin to commit to what they were until nearly closing arguments. Now, does that sound like Elie Honig saying, oh, I only have a problem with the pre-trial stuff? Is that what it sounds like? No. What it sounds like he's saying is, there was a problem that the whole way through this, the whole way through it, Trump's team doesn't know. To this day, right now, Trump's team doesn't know what the specific underlying charge was that he was charged with. Now, it's clear that that's the argument I'm making. I'm saying, listen, Pisco, you said this is how things normally occur in a trial. And you said anyone with a cursory understanding of the legal system would know this. Mocking me, which isn't that funny. He mocked me on that panel, but he's upset that I put the word lawyer in quotation marks. Just so you know, that's where Pisco's coming from. Fucking crybaby. I'm not crying about the fact he mocked me. That's fine. I don't mind. A little chirping back and forth is fine. What I'm criticizing is, I think you're full of shit. You're bad faith. You're a fucking liar. You're saying there's basically no... Everybody agrees. Everybody agrees. Anyone with a cursory understanding of the law agrees. I don't care that he's picking on me. I fully admit I'm not a lawyer. It is clear what I'm saying all last night is they have the right to hear during the trial what they're being charged with. That doesn't mean, as Pisco's trying to say, that I'm specifically saying, which I admit, I even clarify later. I'm like, okay, I think I see the problem. I did, during our discussion, clunkily say, I think that during the trial, even if it was known before the trial, you have a right to know specifically what's being charged before closing statements. I stand by that might be true, but maybe not. But that's not the argument I'm making that Elie Honig's making. I'm making the argument that he's saying, no, this wasn't a normal trial. And no, just having the pretrial motions weren't enough. And Pisco's wrong saying, oh, if Elie Honig knew about the pretrial motions, then he would agree that this was enough. He didn't, which means Pisco's argument that this is normal and any person that was in the legal field would know is full of shit. He's full of shit. It devastates his argument. Honig's making three arguments. Pre-trial, it wasn't in the indictment. It wasn't specified what the charge was going to be. During the trial, it wasn't specified. The judge didn't force them to specify until almost closing arguments. And then jury instructions. The prosecution begged them to keep it vague, which they did. That's the argument. It's a due process argument. Trump still, the whole time through, they didn't know specifically what they were being charged with, and they still don't know after the trial. That's it. That's the argument. It is clear as day, as I'll show you from specific post here in 1 second. All right. Pisco says, so desperate for the W that you're reposting Honig's deceptive response, which taken at face value crushes your argument. You said Honig was not referencing pre-trial, but the right to hear in trial. Honig says he's only talking about indictment. That's exclusively pre-trial. But you just heard Honig say, am I wrong? Like, seriously, I'll listen to people. Am I wrong? Does this sound like Honig saying he only has a problem pre-trial?
Specificity, what he's being charged for, what he's being tried for. That's why we have indictments. Now, the indictment in this case does not specify what the underlying quote-unquote unlawful means are.
Talking about the indictment. Absolutely. Pisco's right. He's talking about the indictment.
And in fact, and I found this to be shocking, Frank.
And, he says, and he found this to be shocking.
The judge did not make the prosecutors commit to any of those unlawful means until we were just about into closing arguments.
You see? So when Pisco says, it's clear he's talking about pretrial, not the right to hear in trial. Honig says he's only talking about indictment. That's exclusive pretrial. That's not true. He is, as I'll get to later, he is saying there is a problem. They didn't know pretrial. Bad. They didn't know during the trial. Even worse. And the judge purposely left it vague and they still don't know after the jury instructions. The worst. That's what he's saying. The whole thing. Absolute bullshit. Crushes Pisco's argument. Now, here's post he put of me. I said they're talking about the right to hear the charges in the trial. Now, you heard the Abrams clip, and you heard that clip. Both of them are saying, during the trial, we didn't even know. We don't know what the charges were during the trial. That's what they were talking about there. The reason in Honig's response, which I'll show you right here, this is Honig's response. And see what Pisco highlights? You highlight one sentence of my piece, obscuring the next two sentences, which make it clear I mean notice by indictment. Yes, he is specifically talking about the indictment there. But that's because he's directly addressing the argument, you said they didn't know about it pre-trial, but here's these motions. To which his response are, I'm talking about they didn't know pre-trial from the indictment, which is where they're supposed to find out about this. So, of course, in referencing a conversation talking about what is your problem pre-trial, Honig's response is going to be, here's what my problem was pre-trial. This statement does not say, I'm only upset it wasn't in the indictment, but everything else was peachy. That is not what this says. I know you're upset you got bodied by good logic. So I told him to cope. He said, you said Honig wasn't referring to pre-trial notice, but was referencing trial stuff. Read this sentence again. You said Honig wasn't referring to pre-trial notice, but was referring to trial stuff. An indictment's pre-trial. Honig claims all he was talking about was the indictment. Just take that one sentence. That's from today. That's Pisco clarifying. And then he says, I'm concerned for your health, actually, dude. See, Pisco's, I just want to be clear. So when Pisco puts all the copium memes and starts with that shit, right? And then I come back at him and he's like, oh, dude, I'm concerned for your health. You're going crazy. You have dementia. All fine. No problem. But I put the word lawyer in quotes on my stream and he goes, I won't talk to you. That's too much. Why are you insulting me? You see? Let's go back to that sentence again. Here's Pisco's sentence. This is from today. This is him clarifying. He said, I said he wasn't referring to pretrial notice, but was referring to trial stuff. An indictment's all pre-trial. Honig claims all he was talking about was the indictment.
So that's is a defendant is entitled to notice in advance of trial with specificity what he's being charged for, what he's being tried for. That's why we have indictments. Now, the indictment in this case does not specify what the underlying quote-unquote unlawful means are. And in fact, and I found this to be shocking, frankly, the judge did not...
Now listen, before I play this clip, Pisco's a good faith person who knows what he's talking about. So you absolutely know. And Pisco saw this clip at least 3 times, or 2 or 3 times I posted it to him. So he saw this clip. And he's claiming that this let me just find it. Oh, now I can't find it. Where's it at? He's claiming that this means, keep in mind, this statement came out after that video I just showed you. He's responding to someone saying, you said they didn't know pretrial, but what about the pretrial motions? And Honig says, hey, Ryan, I respect you. You highlight one sentence my piece, obscuring the next two sentences, which I made clear that by notice, he means indictment, which is the actual criminal practitioner knows is different than mentioned at some point. What Pisco wants you to believe is that quote means he didn't say that there was a problem during the trial. He just said pre-trial. That's what Pisco wants you to believe. That's how bad he's trying to gaslight people. You said Honig wasn't referring to pre-trial notice. I did not say that. I said he was referring to that and during the trial. He says an indictment's all pre-trial. Honig claims all he was talking about was the indictment. So given that, and you know Pisco's a lawyer, and you know how smart he is, and you know he's good faith, there's not a chance that we're about to hear this guy say, and by the way, I had a problem with what happened during the trial. There's no chance, right? Because he just clarified that Honig made it clear. The only problem he had was pre-trial, right? That's what Honig said.
Unlawful means are, and in fact, and I found this to be shocking, frankly, the judge did not make the prosecutors commit to any of those unlawful means until we were just about into closing arguments. So that's going to be appeal issue number one.
Now, here's what's mind-blowing. Everybody that followed that thread yesterday saw that clip, including Pisco. Now, it doesn't take a genius to read this and say, oh, he's talking about specifically in regards to the pretrial motion, he meant the indictment. Not as Pisco's trying to gaslight you into believing this here proves, it devastates my argument. It devastates it because it proves that Honig's saying, nope, I didn't have a problem during the trial. I only had a problem pre-trial. I don't know how clearer I could fucking win this debate and spike the ball. It doesn't get more bad. Again, he could have just said, shit, you're right. Honig did say that. And that would have been the end of it. But he can't do it. He can't do it. He cannot do it. He cannot find it in himself to say I'm wrong. Just like the Jabal Bowman thing. He says, there's no way he didn't intend for the alarm to go off. By the way, I made a thread in that this week. He said, when I brought it up the other day, he said, I don't remember ever having said that. I don't remember. Bullshit. So I refreshed his memory. Of course, he didn't respond. He said it's inconceivable that he pulled the alarm not thinking it would go off. And he also said lying to cops is a big deal that should be prosecuted. Okay, problem solved. Case closed. My whole argument is there's a double standard. They don't go after Democrats like they go after Trump people. So here we have. He told law enforcement, I didn't intend for the alarm to go off. Pisco said that's inconceivable. Of course he did. And Pisco said lying to the cops is serious and should be charged. So surely now Pisco, he would say, okay, you're right. They should have charged him and they didn't. This is what, if I'm Pisco, this is what I say. Yeah, you're right. He clearly lied. They didn't charge him. That does seem to be an example of a double standard. Maybe they didn't think they had enough evidence, but clearly, yeah, he lied. But I don't think that's a huge deal, Rob. That's one small instance. I don't think this is a big deal in the large scheme of things. But he can't say that. He can't. He can't say it. He says, oh, no, I don't think that's a lie. Really, Pisco, here's your quote saying that it would be inconceivable. So if it's inconceivable, that means it can't be true. So when he says, no, I didn't intend for the alarm to go off, and you say that can't be true, that means he's lying. Inconceivable was the word he used. Okay, so he's lying. He goes, well, no, it's not a lie. Because when he says I didn't intend for the alarm to go up, what I really mean is he did intend for the alarm to go up. That is, I can't even come up with a hypothetical that is a better example of bad faith. That's it. And then, when I bring it up, like when you watch me when I bring it up on the debate I had with him with the Crucible, his response is, but why would I lie? Why would I be bad faith? I don't know. That's exactly what I'm asking myself. Why the fuck would you do that? Why would you sacrifice any shred of dignity and integrity you had for nothing? For a nothing argument? Which means you literally cannot trust the fucking words he says. He'll just say, no, I said the opposite. Here's your quote. No, it's the opposite. Don't believe me? He says this means that Honig's only talking about pretrial, despite the fact that he heard me play this multiple times.
Now, the indictment in this case does not specify what the underlying quote-unquote unlawful means are. And in fact, and I found this to be shocking, frankly, the judge did not make the prosecutors commit to any of those unlawful means until we were just about into closing arguments. So that's going to be appeal issue number one. I was never put on specific notice of what I was being tried for. Appeal.
Huh. Whoops. Here's my response to him on his thread, because he had to quote tweet. I said, the cope is reaching epic levels. Honig destroys Pisco's entire argument that this was a normal case regarding the underlying charges and how they were held back till near closing arguments. He said over and over and over that this was normal, and anyone who knows about trials would know to look at the pretrial motions, and that it was clear that Honig made his statements because he didn't read the motions. I said, I don't think so. Read the linked post. I also provided screenshots. I almost exactly outlined what Honig's position would be. He had a problem with the lack of specificity in underlying charges. 1, pre-trial, 2, during the trial, and 3, with jury instructions. I said we'd probably find out soon, as it was the weekend and Honig would probably comment soon. And he did. And wouldn't you know it, my theory was absolutely correct. Pisco tried to bullshit everyone and claim it was so obvious that this was how things are normally done, and Honig just hadn't read the motion. But he was wrong, and he is a liar, and he knows this is how, and he is a liar that this is how things are normally done. At least according to Honig, whose credentials and lack of being proven bad faith liar like Pisco leads me to trusting him. Here you can see me from last night responding to Pisco before Honig's statement of clarification today. Oh, I don't need these. Pisco says, in the article, he literally says in advance of trial. Obviously, the problem in Honig's mind is exacerbated because he thinks it wasn't clear until jury instructions. But there's no doubt if it was clear pre-trial, Honig's notice issue goes away. And it was clear. And I say, no, as explained to you several times, he had 3 problems. Pre-trial, during trial, and jury instructions. The original argument we were having was about just the article. In it, you said he just didn't read the pretrial motions. I said that may be, but it could be that he didn't find the pretrial motions to be sufficient. I said I'd be shocked if he knew this was normal to not bring up the specific charges in trial, but to have them in pretrial motions, and he just was lazy and chose not to look for them. Or he didn't know that this was the normal procedure, which would make him laughably incompetent. That was our entire debate. Perhaps these motions give a list of theories normally, but then the indictment or the other pretrial motions get more specific, and he didn't feel this was enough or normal. Do you see that? Perhaps he thinks that it needs to be in the indictment and be specific. This is me last night. Then listen to what I say. The most important part of our argument was your claim that this trial and the prosecution not outlining the specific underlying crime until closing statements when the defense doesn't get a chance to respond was normal. It is clear Honig disagrees and was shocked by this. The idea that if he didn't read the pretrial motions, and once he does, he will come out and say, never mind, I was completely wrong. The specifics were specifics were their pre-trial, and thus I have no problem with the fact that the judge didn't force them to commit during the trial because they already committed. Seems highly unlikely. We will see. It's Sunday. Perhaps he will be on TV tomorrow. No doubt by then, or perhaps he'll write, I spelled right wrong, what a fucking idiot. Perhaps he'll write or be on TV tomorrow. No doubt by then he will be made aware of the pre-trial motions if he hasn't already. Quote, and then I say, I bet he knew of them even when he wrote the article and didn't find them sufficient. So if you're right, then either he will have to admit that he was wrong, or surely at that point you will have to admit that I'm correct about what he is saying, or he is doubling down and is now blatantly lying. play steelman positions as best as possible, shall we? Let's go back to Pisco's claim here. He's saying, in Honig's mind, it's exacerbated. I agree. But there's no doubt that if it were clear pre-trial, Honig's notice issue goes away. And it was clear. I don't think that's true. I think Honig's saying, I don't know. He's saying that there was a clear notice issue, at least with the jury instructions as well. But theoretically, that argument could be true. But that's not the argument we're having. So we're kind of two ships passing at this point. But I clarify exactly what my argument was, which was, he's saying there was a problem pre-trial, during trial, jury instructions. Pisco said this is normal. I said, if it's normal, then why would this senior legal analyst have such a big problem? And Pisco's explanation was because he didn't know about the pre-trial motions. To which my response was, okay, if that's true, when he speaks next, he'll say, I didn't know about the pre-trial motions. So surely that solves my notice, my due process issue. So I was mistaken. But he didn't say that. And I said, my guess is he knew about them. Or at least once he finds out about them, he'll say it's not sufficient because it needs to be in the indictment or something. That's how it would normally be done. That's the argument we're having. There's even more. Classic debate between Pisco and I in 3 pictures. What did CNN senior legal correspondent Elie Honig mean when he said Trump's defense wasn't provided proper notice of the underlying crime? Pisco says he didn't read the pretrial motions and that's why he had a problem. I say he almost certainly did, but found those motions to be insufficient because maybe they should have been in the indictment. Honig says the pretrial motions were insufficient because the underlying charges should have been in the indictment. Game, set, match. Here's what Pisco said yesterday. I don't have any earthly idea why Honig and Abrams are unaware that the defense had ample notice of the prosecution theories. My guess is they are lost and didn't do their homework and made false statements, which they've been spread and echoed by others. He's saying they didn't know about the pretrial motions. That's what he's saying. They were unaware. In other words, his answer here is, oh no, it's not that they're saying that the pretrial motions, they're aware of them, but that's not the way things are normally done, or that's not sufficient. That's not his argument. His argument was they were unaware. So, here's his argument. They're unaware. Here's my argument. Perhaps these motions give a list of theories normally, but then the indictment or other motions get more specific, and he didn't feel this was enough or normal. Here's Honig's statement today. Let's make it clear by notice by indictment. It needs to be in the indictment, he's saying, which, as the actual criminal practitioner knows, is constitutionally and practically quite different than mentioned at some point. Blown out. Absolutely blown out. But let's steelman Pisco even further. Okay. But did I change my argument? Now, that argument that you just saw that I made was literally the last that either of us posted about this last night. And you saw, I clarified. I said he has 3 problems. You saw it. But let's go. Did I find this? He does another quote tweet today. Which, by the way, I will admit to being petty, and I started quote tweeting back. If he's going to do that shit to me so it's impossible to see the arguments, I'll do it to him. So he does it again here. Instead of just responding on one thread, he's got a quote tweet. We'll get to that in a second. He says, remember, I just want to be clear. Here, wait. Give me a second. Let's do it here. Remember, this is what Pisco says. He's busy. Here's what he said. Well, he can't join me. I said, you want to call into the show? He says, this was just before I started the show at 9:12, so an hour ago. Now, I'm busy for the next hour. At any point, not inclined in the slightest to cede muting privilege of power view of a history abusing. When did I ever mute Pisco? Maybe one time in the fucking probably over 100 hours that we've talked. If you want an example of a good discussion, see me with good logic. And he says, as an example of your terrible manners and why I have no interest whatsoever in going on your show as a guest, see the title of your stream and putting my profession, lawyer, in scare quotes, implying I'm a fraud. I would have never attacked your profession. I think I'm broken raw, but I'm concerned for his well-being. %90 of the posts that he has with me on X is him being a prick like that to me. Which is fine. I don't give a shit. Whatever. It's a gamesmanship thing. I don't give a shit. How dare you insult my profession? What a fucking baby. In addition to being a bad faith incompetent liar. What a baby. Oh, how dare you. I would never insult your profession. How dare you. Oh, no. I'll put post to you saying I've broken you and you're on copium and mocking you. You don't know what the fuck you're talking. But oh my goodness, how dare you? Oh, it's Pride Month. And on Pride Month you insulted my profession. You know he is seething. Blown the fuck out. Crushed. I'm so... Rob put my profession in scare quotes. Oh my God, I would never do that. I would never. I'm so polite to Rob. What a child. But here he is, he's broken me. I think he's broken. Concern for my well-being. Rob's forgotten that his position the last few days Honig was talking about disclosure issues at trial. When Honig claims this is not the case, he did not, as I showed you. Rob invents some new convoluted mess. But let's steelman his position and at least look at what he's quoting that I said. Said on the J-Stock panel, I was brought in the issue of defense not knowing what the underlying crime was that they were using until the prosecution's closing arguments, which they didn't have a chance to respond. Pisco and another lawyer basically mocked me, saying this was ridiculous, as pretrial filings included these. I pushed back that it seems that even if this was shown in pretrial motions, the defense have the right to hear and respond to what the underlying crime is in the trial in front of the jury. Right! I may not be a lawyer, but if my argument was so absurd, how are the other legal experts, including ones that don't like Trump, such as Dan Abrams and CNN's legal correspondent Elie Honig, raising the same issues as a possible grounds for appeal? What I'm saying here is, during the trial, they have the right to know what specific charge they're going. So if there were all these theories of what they could talk about before the trial, they have the right during the trial to know. They have the right to hear and respond to what the underlying crime was in the trial. Now, yes, I am and fully admit that I had said previously that even if it had been in the indictment, that it should be brought up in trial so they have a chance to respond. But it is clear what I'm saying here is the problem is they didn't have a chance to respond to the specific crime. Then he quotes me again. Did you read the exchange? They're talking about the right to hear the charges in trial. Right. Not necessarily that the charges have to be read. They have the right to know what the charges are, to hear them in the trial. It's clear they're implying it's abnormal in the course of a trial for the prosecution to outline what the underlying charge will be only in closing statements when the defense doesn't have a chance to respond. If you're right that this is completely normal, then surely Abrams and Honig would know that they would have to go to the pretrial motions to see the underlying crimes like this as usual in trials. It's clear what I'm saying here is they didn't know the charge until closing statements, and even then they didn't really know. If you're right that's normal, then the normal procedure is to go to pretrial motions. So it's clear that I'm saying, oh, if that's how it's normally done to the pretrial motions, what I'm talking about is the right to know what the crime was during the trial. Answered previously. I'm saying Honig is saying it's not normal for this to not be discussed during the trial until closing arguments because it doesn't give the defense the chance to respond. You're saying it's normal, which means that Honig's incompetent. It is clear what I'm saying is the problem that Honig and Abrams are saying is the defense during the trial did not know what the specific charges were. Pisco says, I say, you're pretending you're worried about my mental health? Yes, Honig says he also has a problem with the charges not being specified in the trial as well. His entire point is they weren't specified appropriately before the trial, and they weren't specified appropriately during the trial. And so he had a problem that they weren't specified until closing statements, which is exactly what I was saying. I lay it out as clearly as day here. Now, it's hard for people to follow because there ended up being a bunch of threads because you're bad faith and often quote tweet instead of responding in the thread, but I'll post it here. Honig's statements today does two things. One, it shows your claim that he only had a problem because he didn't read the pretrial motions were absolute bullshit as predicted. This also shows that despite your insistence that this was so clearly the normal way a trial works, and anyone who knows trials would know that this is, again, bullshit, because Honig has a big problem despite knowing about the pretrial motions. Second, my summary of the situation listed below is almost exactly spot on. Go ahead, everyone, read it. Don't listen to Pisco's take on what I meant. I'll provide the screenshots and the link for you to read. Don't worry, my mental health is fine, Pisco. Perhaps you ought to look inward. He says, Rob, when you say Honig is saying that he also had a problem with the charges not being specified in the trial as well, this is literally the opposite of what Honig says. No, it's not. He says Honig is claiming it doesn't matter if it was outlined at some point. He was only referencing the indictment. It's not true. He's responding specifically to someone said about his problem pre-trial. I said, in that portion of the article that you highlighted, you dolt, I provided the video of him talking about his problem specifically at the trial. You know this. He is answering a person saying, well, pretrial motions show the underlying charges. And he's saying, no, that's not enough. It should have been in the indictment. He's not saying, and therefore, if it was in the indictment, I wouldn't have any other problem with that. That's not what he's saying. He's saying he had a problem as well with how it was done in the trial. I said, heck, if you read the highlighted portion that poster has responded to shows, he specifically mentions that the defense didn't get to hear the charges until right before closing. Clearly, this shows he had a problem not just pre-trial, but during the trial. How can you pretend not to understand this? Then Pisco says, he's stating in essence, no matter what you disclose, you can't cure the initial defect of lack of notice in the indictment, which I strongly contest, but that's his view. This is not inclusive of the disclosure problem at trial. It just isn't. I said he specifically says the problem the prosecution and judge did during the trial. His argument, which you know you're just being bad faith, hey, the defendant has the right to hear specific charges so they can defend themselves. He has the right to hear them before the trial in case he didn't. And it's worse because he didn't hear them specifically during the trial. And he says, I agree, that's the best reading of Honig's statement, is that he was stating the defense didn't have notice of the theories before the trial. Even myself is clowning on him. Everyone, including myself, everyone is not clowning on him. Pisco is. Where you're dead wrong is the notion that Honig is saying, regardless of pretrial notice, some specific disclosure is required during the trial before closing. Honig claims what's required is the indictment. And then he quotes what I already showed you. It is clear they are implying it's abnormal in the course of a trial, the entire course of it, for the prosecution to outline what the underlying charge will be only in closing statements when the defense doesn't have a chance to respond. Read the next paragraph. If you are correct, this is completely normal, then surely Abrams and Honig would know that they have to go to the pretrial motions. Now that proves that what I'm saying is they're saying there was a problem, not just because he's trying to make the argument. I'm saying, they're saying that there was a problem just during the trial. And had it been in the indictment, that would be okay. I'm saying no. What they're saying is, we didn't know we had to go to pre-trial motions. That implies my argument is, their argument is in totality, there was never a specificity of charges outlining over the course of the trial. During the trial, the defense didn't have a chance to respond to the specific charges because it was never outlined. In their estimation, that's what they're saying. I said, I never implied Honig was saying that. Again, I was quite specific. He was saying the whole thing is stretching the boundaries of due process. Defense weren't informed properly before the trial, during the trial, and in the judge's instructions. Can you at least admit you were wrong on the two most important points? One, you were wrong that Honig made these statements because he hadn't done his homework and didn't read the pretrial motions. Two, this shows you were wrong when you implied anyone with a basic understanding of trials would say the way the underlying charges were disclosed in the trial was normal if they were aware of the pretrial motions. You were wrong. You know it. I know it. You're just hoping that you could BS your way out of everyone reading. Now, then this person says, me trying to figure out the original claim. I said it's simple. Pisco says Honig made the statement because he was unaware of the pretrial motion. I argued with him all day and clarified exactly what I meant. That the jury had a problem with, that he had a problem with the actions before, during the trial, and with the jury instructions. That I assumed he was aware of the pretrial motions and probably didn't find them sufficient. Honig's statement says the same thing. It's clear as day. Pisco says, we're not arguing about why Honig said what he said. We're arguing what he said and what he did not say. Note in the very screenshot I said I had no earthly idea why Honig would say he gave... No, what he said, if you look at the screenshot, he does say, I don't have any earthly idea why Honig and Abrams were unaware that the defense had ample notice of the prosecution theories. Because what Pisco's saying is they didn't know about the pretrial motions. That's what he's saying. My guess is they are lost and they didn't do their homework. He's saying, I don't know why they didn't, but they didn't. That's what he's saying. Even here, he's dishonest. Pisco's saying Honig made the statement because they were unaware of the pretrial motion. He can't even admit that. He's like, no, I was saying I have no idea. No, you weren't. You were saying they didn't read the motion. I don't know why they didn't read it, but that's your argument. They didn't read the motion. When I accurately say Pisco's argument is they didn't read the motion, he lies. He says, I didn't say that. I said, I have no earthly idea why Honig would say what he said and give you my best guess. Bullshit. He's saying he doesn't have an idea why they didn't read the motion. I never disputed that Elie might have a problem with the indictment. It simply wasn't something I was arguing, hence why I said I didn't know. By the way, Elie never states he was aware of those filings, and he's doubling down on an obviously misleading statement that's drawing widespread ridicule. Right, amongst the CNN viewers and the Pisco crowd. Now, my question to you is, I already showed you that Pisco, last night, in the course of our debate, actually tweeted at Elie Honig, or I keep calling him Eli, E-L-I-E. I want to say it's Elie. Tweeted at Elie Honig and said, hey, when you made this statement, were you aware of pretrial motions? Why would he do that in the middle of our debate? If we weren't talking about what Elie Honig was, why he was saying this, you saw it in every tweet I'm saying. I'm saying this is the argument I have. I clarified it. That whole last spiel, if that's not what we were talking about, why is he talking about not having an idea? Why was I doing this? I'm sorry. The original argument we were having was about the article. You said he didn't read the pretrial motion, and I said that may be. In fact, if you want, I For you. I'll again do this. I'll go back and go to the original thread if I could find it. Here, again, here's Pisco. Remember, no one was talking about why he did this. Here's Pisco's tweet to Elie Honig. Hey, long-time listener here. Can you please clarify whether you made the attached statement regarding notice? Were you aware of the pretrial motion? Right, because that's exactly what we're arguing about. Why did he make that statement? Look, here's another one. Pisco is responding. I said, great then. So given the magnitude of this case and how bad their false statements are, this is Honig and Abrams, they have no business being in air discussing legal matters. Further, seeing as how this is so egregious, I assume you'll never trust their opinion again. I myself will choose to believe this is not the normal way trials work. That is what we're arguing the entire time. He says, look at this false dichotomy. If someone makes a big mistake because they didn't read them, then he tries to gaslight you today and go, that's not what we were talking about. Yes, that was the entire argument. Another example. Once more, quote tweeting instead of responding to the thread, you hack. Your questions have already been answered and you've ignored it. 1, they're clearly saying there's a problem abnormal for the defense to not get notice of Bragg's theory during the trial. If that's not what they are saying, the answer, which of the 2 scenarios I outlined in my previous post that you believe, are they intentionally refusing to read the pretrial motions even though they know that's the normal procedure? Or are they so stupid they don't know that's normal? Irrelevant to the issue at hand, the judge outlined the law to the jury. Their argument is not knowing by what Bragg would go for in trial, the defense didn't have the ability to argue against it. Now, then he says, okay, the defense was well aware in the trial regarding the people's theories. Yes, the extent they are complaining about prejudice because of notice. That is ridiculous. It's ridiculous because the defense had notice. I said, notice again how he won't answer my questions. This is the norm for him. Anytime I ever ask him a question, he rambles on and on and on without answering. Even when communicating through writing, he can't answer. This is what someone who knows they are lying in bad faith does. People may think I'm wrong, but at least I answer in good faith. Then finally, he answers, I don't have any earthly idea why Honig and Abrams are unaware that the defense had ample notice. I said, great, so then given the magnitude of the case and how bad their false statements are, they have no business being on air. It's exactly what we're talking about. I haven't even got to the best part yet. Well, yeah, that was the best. There's one good part left. This was the original thread. Does it sound... What do you think is the thrust of what I'm saying here? On a J-Stock panel the other night, I brought the issue of the defense not knowing what the underlying crime they were using until the prosecution's closing arguments, of which they didn't have a chance to respond to. They didn't know until the end. They didn't have a chance to respond. Pisco and another lawyer basically mocked me and said the pretrial motion filings included these. I pushed back that it seems even if this was shown in pretrial motions, the defense should have the right to hear and respond to what the underlying crime was in the trial in front of the jury. So they should have known what specifically was being gone for in the trial. Just because there was a bunch of theories out there, they should know exactly what they're being charged with in trial. They basically told me that's not how trials work. The crimes aren't brought up during witness testimony, and it's not out of the ordinary for the crimes to be charged to not be outlined until the closing statement. I may not be a lawyer, but if my argument was so absurd, how are other legal experts, including ones that don't really like Trump, such as Dan Abrams, raising the same issue. That was the original post. Now, one more thing I'm looking for. God, this is such a pain. Does everyone see my frustration with the way he quote tweets? Is this replies? Yeah, it has to be. No, it's not. Okay. 1 second. Almost done. Okay. Pisco says, I've already shown multiple screenshots that he again makes another thread. You see this? Instead of responding, he makes another thread. And this time he doesn't tag me. He just says Rob so that I can't respond. Because he knows that Honig's statement this morning blew him out of the water. So he has to start a new thread, not tag me. That's what he does. And he says here, I've already shown multiple screenshots that definitely prove this and now a video clip. The amount of gaslighting is absurd. Let's see the video clip that he showed. Okay, so Pisco again. Now what he's claiming here is this clip's going to say that our argument was just me saying that Honig said it's not a problem, even if it was in the indictment, he had to say it in the trial as well. Listen to what I say. Okay, so Pisco, again, deflects from the fact that he actually said this, and I'm not getting blown out because, as you can see, the opinions I have are for people that have a far larger history of involvement in the judicial system and are more established than Pisco that are raising the same questions I did. I didn't pull them out of my ass. I pulled them from senior CNN legal correspondent who hates Trump, who was the person who brought up this part about it seems odd that the prosecution didn't bring up these underlying crimes until the closing statements. That seems odd to them. Now, if Pisco's right that that's so laughable, how could anyone think that? Clearly, that's the normal way things occur. Why? Okay, so Pisco again. Do you hear what I was saying there? This is the section that he clipped. Do you hear what I was saying at the end? Well, if it's true that that's normal, then why are these legal experts saying this? Right? Listen what I say. Nowhere do I say they're saying, oh, Honig saying it specifically has to be during the trial. What I'm saying is, they didn't hear it until closing statements. In other words, the entire way through, they didn't hear the specifics. Both pre-trial and during trial. That's what I'm talking about. Pisco wants to say, no, we are never having a discussion about Honig. Why didn't Honig know about the pre-trial motions? We never talked about that. That's even here what I'm saying. I'm saying, listen, I'm not just some buffoon. I read legal experts that say this, and Pisco's trying to gaslight his audience saying, Rob didn't know the technical term for the pretrial motion. Trust me, this is how normal shit goes. Anyone in the legal profession knows this is how normal shit goes. That's how it goes. And you could hear, he clips out where I'm saying it, but you could hear even here, right at the end of this clip, I'm saying, so if that's true and this is normal, why are these people saying that this isn't normal how a trial was ran? That's my argument. That's what I'm talking about. But even this part where he thinks this is me saying, oh, Rob's saying specifically, even if it was in the indictment, the problem is it wasn't brought up specifically at trial. That's not what I'm saying. I'm saying the problem is the defense didn't know the specifics of the trial until closing arguments. Meaning the entire time before, pre-trial and during the entire trial until closing arguments. That's what I'm saying. Listen. Prosecution didn't bring up these underlying crimes until the closing statements. That seems odd to them. Now, if Pisco's right that that's so laughable, how could anyone think that? Clearly, that's the normal way things occur. Even the video he puts. But here's the thing. You want to know what's funny? All of the fucking gaslighting he's doing in all these clips, I actually said at one point I explained this to him the night before. I explained it. I admitted to possibly being wrong, which is something he's incapable of doing. And he knows, he saw the tweet. Now this person responds to Pisco, says, I've shown multiple screenshots that definitely prove this, and now a video clip. Prove what? Despite his efforts to rewrite your history, this all started because Rob claimed the jury should have been informed about the legal theories before the instructions. What did I say in the clip? Did I say jury? Hey, you ready?
Let Rob
the
get
point
a
that I
sense
was not in closing statements, but during the trial, what these underlying crimes were. Because it is the defendant's right to be able to contest these things that are brought up to the jury. They should be explaining to the jury, not in closing statements, but during the trial, what these underlying crimes were. That would be the portion when the defense would be able and articulate why those underlying crimes aren't things that should be looked into or that the defendant was innocent of, etc. Instead, what happened was the judge continually... Then I'm saying the judge. Now, this is closer to what Pisco's saying. But I'm clearly saying here that they have the right in trial to know the charges. I did say hear them in the trial. I could be wrong about that. And you're saying, yeah, right, you're just saying that now. Watch. This is from... Pisco put this clip today. Here was from last night. Well, actually, this is still from today, but I quote from last night. This person says, Rob, I assumed at some point before the trials they outlined something. The point I'm making is this. When did they bring it up in the trial? Oof, Rob Noor. This is Pisco's entire point. I say wrong. Even if I'm wrong, that doesn't mean Pisco wasn't wrong. And he was far more wrong. He said Honig only said that because he hadn't read the pretrial motions. That is absolutely definitively wrong, without question. Second, although I did make the argument that it should be brought up at trial, even if there was a pretrial motion, the point I was making with Honig was given the vagueness, he believes pretrial, the fact it wasn't brought up at trial until almost closing was terrible. Now, it could be I'm wrong in the point I made on the panel that I thought it should be discussed during the trial. But I'm obviously saying that because I am reading Honig and others saying it's absurd the charges were never made clear to the defense, and I feel the defense should have the right to argue against it at trial. But even if that part's wrong, which I'm not sure what it is, I am far less wrong overall than Pisco. And I certainly clarified last night what my position was with Honig, and I was exactly right, as you can see below. And then finally, getting this saga to an end. So many threads you have to go through. We'll read this last thread. Well, no, we'll read the second part first. I say, also notice the difference between Pisco and I. Here I fully admit to the possibility of being wrong, and I exactly clarify what my main concern is, which was last night. and yet he still pretends to ignore my clarification. I'm not perfect. I mess things up. I admit when I'm wrong. Compare that to Pisco. He can't do it. He'll change the meaning of words, deflect, etc. Here's Pisco. From last night, he says, as I've explained to you numerous times, the judge gives instructions to the jury on the law at the end of the trial. Honig's incorrect problem relates to a due process violation of the notice to the defense, not that the jury had a right to hear the legal theories pre-closing. I said, that's evading the point. Now listen, I'll admit to clunky rambling in the panel. I'm aware that the judge gives the instructions, though I'll admit to believing that it was the normal process for both the prosecution and defense to tell the jury how they interpret the laws, such as the defense trying to bring Brad Smith on to discuss what the law means. I'll also admit, upon further reading, it appears that although sometimes it's the case, many times it is not. Do you see what I did there? I said, I'll admit, I looked in, I was wrong. Everybody see that? Want to read that again? See if Pisco's capable of that. This was last night. I'm aware that the judge gives the instructions, though I'll admit to believing it was the normal process for both the prosecution and defense to tell the jury how they interpret the laws, such as bringing in experts like Brad Smith to discuss what the law means. I'll also admit, upon further reading, it appears that although that is sometimes the case, many times it's not. Then read the next sentence. It was clear my issue, which Honig seems to share, is the defense has the right to know the specific crime or unlawful means being alleged before closing statement so they have a chance to respond to them. You keep saying legal theories, and he kept saying, show me where they say the jury should hear legal theories. But that's not Honig or my argument. The problem is the prosecution not committing to a specific charged underlying crime until practically closing. In this trial, Honig is arguing it didn't happen, and he says he was shocked by it, and it's ground for a due process appeal. So I told him last night, okay, because he's acting like the entire point, Rob, the entire point is you were saying the jury had the right to hear these. I did say that. You heard the clip. I did say that. That still may be the case. Again, I'm doing some reading. Some states it says that the opening statements have to include the specific charges. I have not found that New York says that. There is a question, perhaps, of whether or not specific charges have to be outlined during the trial. But I'm willing to say I'm probably wrong. I'm willing to say that. I'm also willing to say that I was definitely wrong when I said that I thought that it was always that both the prosecution and defense argued about the interpretation of the law. I was wrong. Sometimes that occurs, but a lot of times the judge does not allow that, and the judge gives the own instructions. Hear that? Twice I'm saying that I could have been wrong. But the big point that I was making is the big point that Abrams was making, is the big point that Smirkanish was making, is the big point that Honig was making, is the big point that that Dershowitz made, and many, many others, which was, we don't know what the fucking charge is at the end. They didn't know before the trial specifically, they didn't know during the trial specifically, and we don't know at the end of the trial. That's the point. That's the argument I'm trying to make. And Pisco said, that's normal. If I was only talking about the jury's right to hear it during the trial, why over and over and over in those quotes that I showed you was I repeatedly saying, if you're right, that a normal person would know if it's not brought up in trial, you go to the pretrial motions and that's how it's normally done. Why would I even be saying that? I would say, no. Even if it was in the even if it was said beforehand, it has to be said here. I said it over and over. Again, in the response that I made to Pisco's fan. Oh, Jesus. So ridiculous, this quote tweet and shit. So he does it here again. At least there he includes my tweet. Quote tweets it. Oh, I know where to find this. Never mind. Right here where he quote tweets me without tagging me. He quote tweets someone else and doesn't tag me. Duplicitous little shit. Coward. But Rob, maybe it was a mistake. He's done it several times. I've called him out for this before. Look what I say here. Even if I was wrong, even if you're sitting here saying, yeah, Rob, you were absolutely wrong, that doesn't mean Pisco wasn't wrong. And he was far more wrong. He said Honig only said it because he hadn't read the pretrial motions. That's definitively wrong. And although I did make the argument it should be brought up at trial, even if there was a pretrial mention, the point I was making with Honig, talking about Honig specifically, was given the vagueness, he believed the fact that it wasn't brought up at trial almost certainly, or until almost closing, was terrible. Now, it could be that I'm wrong in the point I made on the panel, that I thought it should be discussed during the trial, but I'm obviously saying that because I am reading Honig and others saying it's absurd that the charges were never made clear to the defense, I feel the defense should have the right to argue against the charges during the trial. But even if I'm wrong on that part, which I'm not sure I am, I'm far less wrong than Pisco. And I'm not going to look him up, but I asked him over and over, can you at least admit you were wrong? Can you at least admit you're wrong when you were saying the reason he said this was because he wasn't aware of the pretrial motion? He can't do it. You saw what he did. He was like, well, I never said that. I said I wasn't sure. No, what you said was, you're not sure why he was unaware. But he was unaware. That's what you're saying. That's your definitive answer. It is impossible for a legal mind to think there wasn't pretrial notification that was sufficient, because this is the way it's normally done. If it's not brought up in the trial, clearly look at the pretrial motions. That's the normal way it's done. And I said, I don't know. I feel like what he's saying is he didn't see sufficient notification in the pretrial, which means he probably saw the pretrial notices and thought that's not good enough. It has to be in the indictment, which is exactly what Honig says. And then he says it's exacerbated and made worse because all through the trial, they were never forced to commit to what the charge was. And he can't admit it. He can't admit. All he had to say was, okay, shit, you're right. I guess Honig's an idiot. Fuck him. He's a moron. He could have said that. But he can't do it. He has to lie about what he said. Literally a piece of evidence that, again, it does not get more clear than this. I said, here's my theory. Perhaps he thinks these pretrial motion gives a list of theories normally, but then the indictment or other motions need to get more specific, and he didn't feel this was enough or normal. He says, make it clear by notice, I mean indictment, which, as any actual criminal practitioner, is constitutionally practically quite different than mentioned at some point. Exactly what I said. Only a bad faith hack could look at that statement and look at those two statements where I almost verbatim fucking nailed what I said Honig's theory would be. And he didn't say, nah, I don't think that's what. He literally quote tweets and says, blown the fuck out. Rob got crushed. This quote crushes Rob's theory. That's fine, Jeff Aaron. I do get a little passionate. Good for you, man. If that's what you're saying about me. He also is being... Though I will agree, during debates, maybe I should calm it down a little, so not a bad criticism. Lastly, I will show the thread. This is the thread I made about how bad faith he is in general. If you go to my post the last few days, you can see I have a large amount of exchanges with Pisco. Now, in this thread is going to be meta, but I want to show once more how bad faith he is. Pisco will flat out lie and say words mean the opposite if it means avoiding admitting he was wrong. It's been showed when he claims Jamal Bowman didn't lie because he said to the cops he didn't intend for a fire alarm to go off, when he really meant he did intend for it to go off. And just today, he's pretending his argument last night that CNN legal analyst Honig only had a problem with the lack of disclosure to the Trump defense of the underlying crime was because Honig made a mistake and didn't read the pretrial motions, which a post today from Honig shows is not true. He knows of those motions and thinks it's a problem anyways because it wasn't in the indictment, which I accurately predicted. But I want to focus on something petty and bad faith that he does frequently right here on X. Most people will have a discussion on a thread. I say Trump good. Person responds, no, he's not. Then I respond to them. But not Pisco. What Pisco will do is quote post and then respond in that manner. I post Trump good. Pisco quotes it and creates his own thread and says Trump bad. Then I respond on his thread. My guess is he does this because it makes it harder for people not following him to see, and it ensures his post will be the top in the new thread and will be seen by more than my response, so he could get more likes and feel like he's a winner or something. Then what happens is the threads spawn off onto other threads, and then the next thing you know, it's almost impossible to follow the conversation, which is good for him, because then when he's proven wrong, it's hard for people to see exactly what he was saying. I then end up making my own threads in response to this, yeah, I'm petty, in an effort to not get drowned out. And then you get ridiculous situations where you're having the same conversation on multiple threads and posts, and he will end up spamming his same answer as shown in the pic below, which then I have to spam out answers else, or else it seems like I couldn't respond. Like this. At 4:05, this is what I was dealing with trying to respond. 1, 2, 3 in a row, just spamming the same answer. All because he's bad faith and can't respond on a thread like a normal person. But it gets even better. If he gets really blown out, what he will do is he'll start a complete new thread without tagging me. Then he could cope with his followers and pretend I didn't disprove what he was saying. That's what he did today in the link thread. Pisco's a bad faith debater in so many blatant ways. He's a coward and a blatant liar. I wish him well, but it's important that people can see him for he is and keep that in mind when listening to his opinions. And then this person said yesterday, I can't justify the way Pisco's quoting, replying, etc. so consistently. It's really fucking annoying. What do you want to debate about cringy leftists? Now, I asked Pisco if he wanted to come on. Now, I've already shown this multiple times, but you can see all throughout the thread, I'm not going to sit here and claim innocent. Yes, we both go back and forth at each other like petty children, insulting each other. I never take it personally. I still, even in that thread, from the bottom of my heart, I mean this. I don't wish him any ill. I want him to lose his license to practice law. Nothing like that. It's not what I'm saying. I hope he I think he has a girlfriend. I hope he gets married and has kids and has a great fucking life. I do. From the bottom of my heart, I mean that. From the bottom of my heart. But yeah, we go back and forth. That's fine. He does the name calling. I do the name calling. He's snarky and petty. I'm snarky and petty. Fine. This is what he says today. Why he's not coming on. First, he says he's busy for the next hour. Could actually be true. He's not inclined in the slightest to cede muting privileges. How many times have I debated Pisco? How many times have you seen me mute him? I've threatened. I'm sure I've done it once or twice because he just rambles on and on. But how many times have we talked and it's almost never happened? How many? Over and over he's came on my channel and now finally he's like, when's the last time? Do you think he could point to when the last time was I muted him? Of all the times we've talked? But that's what he says. And then he says, as an example of your terrible manners and why I have no interest whatsoever on going on your show, as a guest, see the title of your stream, putting my profession, lawyer, in square quotes and implying that I'm a fraud. I would never have attacked your profession. The logs, tweets, and videos speak for themselves. I was completely correct and you were completely incorrect. Because you can't handle that, you go personal. That's just your personality. And it's the same whether you're beating inferior debaters or getting crushed by me. I'm sorry, did anyone see the tweets we went through and him being a petty asshole just like me the whole time? And he was completely correct, and I was completely incorrect. I don't know if cringy leftists, did you want to debate? My computer probably will crash. Oh shit, now it's downloading updates for Discord. Left immigration. No thanks. If you're the guy I shit on the other day, I do apologize. I was too rude. But I don't want to debate immigration. Also, a little presumptuous of that guy, I will say. What was that guy's name? It wasn't cringy leftist. What was his name? You might be in the way. Does anyone hear my computer just getting ready to explode here? This is not the guy I debated the other night. This is someone who's going to be a troll, almost guaranteed. I'm not debating immigration tonight. I'm not doing it. But we'll see if it's the same guy. I'm pretty sure his name was something else.
You're just getting ready to explode here.
Hey, how's it going?
You're not the guy I talked to the other day.
No, that was my brother.
I don't believe that.
Huh?
I don't believe that.
No, we're biological twins.
I don't believe it. Go ahead, get your troll out. What you were gonna do?
Not here to troll. It's here to have a nice discussion, honestly.
No, you're not. You're not the biological twin of the guy that called in the other day.
Okay, bro.
What was his name?
Scratch.
Scratch what? What was his full name?
No, it's just Scratch, I'm pretty sure.
No, I think you're wrong.
Yeah, it is just Scratch with numbers 9258.
You're full of shit. The chances that you're a biological twin, that's what you're saying? You're biological twins?
Yeah.
Mm-hmm. All right, man. See you. That was worthwhile. If it was that guy, I would have apologized to him. I forget what his name was. But I was too rude. I was. I'm right. That I'm tired of... All the immigration scholars say immigration's great. It just so happens every time we send them somewhere, everyone hates it, and it's miserable. But I shouldn't have treated him like that. Also, I do use the word bad faith too much. Pisco's bad faith. Clear cut. That guy called in the other day. That's not fair to call him that. It's not. I should be better. It doesn't matter that I was having a bad day. It's just shit. I shouldn't have did it. And I do feel bad about it. I really do. And I will have him on to have a civil debate about immigration someday. Which is why I thought, well, maybe that is the guy. Oh, now he says he would have talked about any topic. I would have debated that cringy leftist guy if he wasn't being a troll. If he was... But I'm that guy's twin brother. What a load of shit. All right. Schellenberg. Oh, I didn't talk about Fauci's testimony today. Don't worry, nothing will come of it. That's the... You think Republicans are going to do shit? Not a chance. All right, so to summarize what I was saying here, I'm not going to keep every day talking. Listen, I still like talking to Pisco because I feel like you could get a detailed conversation minutia. But it's purely for my own edification at this point to make him cry and pout and exhibit how bad faith he could be. There's literally, I mean, is there any doubt to anyone watching how wrong he was? Any? And again, he had so many outs. So many. He could have said, okay, you were right. Honig's an idiot. There. You asked me, is it that he's lazy and didn't do his work, or he's just an idiot? He's an idiot. There's an out he could have used. Instead of saying, I never said that. I said, I don't know. I don't know why he said that. Bullshit. Or when I said, can you at least admit you're wrong about that? And admit that this looks like you're wrong about this being normal. It's not normal. Like, that's what blows my mind. Why would you even bullshit us and say, no, that's how it's normally done? Normally the indictment doesn't have the underlying charges. Normally it's not brought up until basically closing statements. That's the normal way. Normal is different than, well, it can happen. It's legal. Do you understand that? So, for example, if he would have said, like, okay, you're right, this is extremely rare. Almost always, they do outline the charges in the indictment. And then most times in the opening statements, they say specifically what the charges are that they're going to prove. They usually do that. But it's not necessarily a violation. There are times when that's not the case. He could have said that. But no. He can't do it. He just can't do it. I'm going to debate him. I'm going to debate him Wednesday. It'll be the same tired old shit. And listen, you heard me today talking just a little before we got into the actual threads, talking about these charges and the 3 layers of the charges. I have a lot to say about it. I'm not going to get to say hardly any of it Wednesday because here's what's going to go. 1, through no fault of Pisco. Well, if you didn't know, I'm doing a panel Wednesday, 2 panels. First, I think is going to be at 6 or 6:30 p.m. Eastern time. And that's going to be me, Admiral Gibbs, and Lactoid versus, well, I think Lactoid's a lawyer, which maybe will be good, versus Pisco, Pondering Politics, and I forget who the third person was. Rashad, who I don't know Rashad very well. I would love to get into the weeds of specific things, but because there's 6 people, everybody's going to take it in a different direction. So instead, I have to adjust my priorities to talking about the things I think are most important, which is going to be the selective prosecution angle, because I think that is the most glaring thing. I think anyone who's remotely objective whatsoever could say they ain't bringing this charge if Donald Trump isn't running for president, if he's not the opposition. They would not do it. Why were they so 6-7 years after? They're still like, I wonder if Trump falsified records as a misdemeanor when he was running in 2016. I wonder if he did that. Let's subpoena. Let's see. Oh, yeah, there he was. And it just so happened the guy that did it, the prosecutor, ran on, oh, look how many times I've sued Trump, and I'll hold him accountable. I'll hold powerful people accountable. Just coincidence. That's all, just a coincidence. Didn't go after Hillary Clinton. Can't show us when they've used this legal theory in the history of the country to ever go after someone to make misdemeanors felonies. Can't show. But we're supposed to believe, oh no, had Trump never been president, if he was just running for local office in 2016 and then in 2018 he didn't run again, they would have still looked at these charges. They would have brought him. Bullshit. Absolute bullshit. Everybody knows it. We all know it. Everyone. But you have to, I know it. The lefties know it. I know that they know it. And yet still they pretend they don't. No. They would have brought these charges against anyone. Trust me. Trust me, they would have. Yep. It's bullshit. This has been the game the entire time. Chuck Schumer told us, if he messes with the FBI, they'll find 6 ways of Sunday getting back at him. Now granted, the New York District Attorney Bragg is not the FBI. But it's the entire establishment. The Democratic establishment has gone after him. They've pierced attorney-client privilege. They've drugged his associates out of their houses at the middle of the night at gunpoint in their underwear while CNN cameras just had to be there. They've gone after, in ways they admitted they couldn't have done with anyone else. They went after General Flynn for no reason. For a legal theory that's never been prosecuted. How many times with Trump people is it going to be, well, we've never had a president whose team was spied on through FISA warrants. We've never had a person tried with the Logan Act, but that's what they investigated Flynn for. We've never had a president that's been indicted with felonies. We've never had a person that's had this misdemeanor theory of make a misdemeanor a felony by saying there were underlying crimes. Never had it happen. All of it used to go after a president of the United States. And we're supposed to believe it's no, none of that was political. None of it's political. It's all just by the book. By the book. It's not political. There is no bias. There is no motivation. It's bullshit. That's the truth. That's what's going on. We could argue about the minutia of, well, actually, should we trust Cohen's testimony on this? That's fine. I'm not saying that's not worthwhile. But in this debate where there's so many people, it'll be hard to focus in on every single detail. So that's where I'm going to spend my time. So we won't be talking much. Pisco might bring it up, or maybe I'll bring up this whole exchange we had here tonight that we talked about. But that's not what I even admitted at the beginning of this. That's not the best argument. It is a potential argument, but it's not the best argument. I happen to be right on the meta argument that me and Pisco was having about what Honig was talking about. And the other reason that it'll be hard to focus on one simple thing is because Pisco's in the debate. And he is incapable of being good faith. And he will ramble on and on. He won't answer yes, no. He'll lie about what he said. He'll lie about what the definition of even simple words are, like did. Oh no, when someone says didn't, what that really means is did. I've never heard a person that says more words without actually saying anything. I get accused of gish galloping. You know what that means? They're saying, Rob, you talk and make a lot of points really fast. That's what that means. With Pisco, it's the exact opposite. He talks a lot, but he ain't making no point. He's just rambling. He's stalling. He's running out the clock. That's what he's doing. And so you're like, oh, I have 3 points I want to talk to Pisco tonight. It'll take 2.5 hours to get through point one. And it'll be a simple thing. When I went in that panel the other night, all I was trying to do initially was go through Elie Honig's article. Now, I went slightly out of order. In that article, you saw the quote. He says about the defense wasn't aware of the specific charge crime. He says it. But he has a bunch of other arguments. So I was just going to go through and say, if this is normal, how is even this CNN legal correspondent saying there's all these problems? How do you respond to this? But I couldn't get to them. Now, I will admit I'm partially at fault for bringing up the Jamal Bowman thing, but I didn't bring it up initially. And the reason I brought it up was because we were getting into that territory, weren't we? Him talking about his expertise. You're not a lawyer. I'm a lawyer, blah, blah, blah. You're also a bad faith sack of shit. So if you're going to talk up your credentials, let's not forget to include that you're bad faith, so that the audience could factor that in. It's not going to... Oh, 1 second, everyone. I'll be right back. Phone ringing. Sorry, late night phone call here. I got a new paperwork thing I got to do here before I go to bed. Nothing. But yeah, that's it. That's the gist of what'll happen Wednesday. And then following that, remember, then I have a second panel, which, believe it or not, is the first panel. Hopefully we get into more specific details and it's more productive. I'm telling you right now, I'm making this, and if you're listening, whoever the dude is, Lethwater Kai or whatever that's running this debate, I'm making that second debate a shit show. It is going to be an absolute shit show. I don't care. That's going to be righty on righty violence. Me, Phil KOE, maybe Lactoid, and who's Admiral Gibbs versus Jebtan, Tiberius D, and Conor. Or as I like to call them, progressive victory points. Now I was apprehensive to bring up the fact he was working for Progressive Victory PAC, but given the exchange we were having in our Discord group for this debate, methinks I'll be bringing it up quite frequently. So it's probably going to get a little testy. Now, I'll say this. I'm going hard at Pisco. I'm not going to go hard as I am right now at Pisco. By the way, during the debate, I'm not going to be... I might say, you're bad faith piece of shit. And we are going to talk about Jamal Bowman Wednesday as well with Pisco. But I'm not going to, be yelling and screaming about how bad faith he is, as bad as I am here when it's just my show. I'm not. Right? And it won't be this bad with Conor. But I am going to call him out. The whole time. I'm going to call him out the whole time. But I can't stress this enough. I really like Conor. I do. And I mean that. I'm not just saying it. Pisco I used to really like. Now, I don't know. I can't say I like Pisco anymore. It's just it's too much. The bad faith is just too much. It's too much. You know, but I don't hate him. I don't dislike him. I don't. But I swear to you, and I mean this, I'm not saying other people, I'm better than other people or that it's always wrong to do this. I'm not going to talk about people's family. I'm not going to talk about their appearance. I'm not going to talk about, you know, I'm not wishing them well, that they get fired or that they, you know, get kicked out of their home. That's not the shit I'm doing. I'm not doing that, you know. So when I'm going hard at Pisco, don't be mistaken. I don't want anyone to do anything shitty to him, to dox him. You could, if you see him, you could be like, "Hey, Rob blew you out, you're a piece of shit," or whatever you want to say. But no doxing, don't do that. We're better than that. And I mean that from the bottom of my heart. I really do. I wish no ill will to any of these people I debate. None. I really don't. I mean it. I hope they live long, happy lives and continue to watch me blowing out the people that are ideologically similar to them. Yeah, John's another person. Me and John are really going to have at it. John and Aftershock got in it the other day. Me and John we're going to go at it. We are. But I like John. I do. I just happen to think on this most important of issues, he's absolutely wrong about basically he'd rather see Biden in office than Trump. I mean, but I have bigger fish to fry going into the election. I'm trying to keep DeSantis people as close as possible to potentially voting for Trump. That's what my focus is. So I'm not really trying to go to war at that point. He unfollowed you and blocked you from his stream. That's funny. You used to be a producer on me and his show. This is funny. And you're blocked. Bam. That's funny. But I still like John. I do. Look, this shit you have to understand, right? We're fucking internet tough guys, you know? You yell at this shit back and forth. I see these people in real life. I'll give you an example. My friend Tom Kennedy, the other day, Trump gets indicted. I come on, I start streaming. My friend Tom Kennedy comes on and goes, "What about when Trump said lock her up?" And I rip into him. Later that night, we're texting each other. We're going to go to Pittsburgh to watch a cricket match because we had a friend that was from, I think, Sri Lanka. And he was really into cricket when we knew him. And we used to, drink with him. And he'd, find cricket matches online that were happening live. We had no clue, me and my buddy Tom, what was going on. But we'd sit there and drink with him and celebrate when he did. We didn't know what the hell was going on. So we're going to go to Pittsburgh to a cricket match. That's just the way I am. You argue and it's whatever, you know. And I'm not saying sometimes can't get out of hand. But I utterly and truly mean this from the bottom of my heart. Conor is a guy with bad takes. And I think that it's absolutely absurd that he calls himself a conservative and work for political victory pack, progressive victory pack. And I'm going to fuck with him about that a lot. In fact, I'm no longer calling him counterpoints. He's progressive victory points when I talk to him from now on. But I like Conor. I do. And I think Conor, even though he makes some bad arguments, and he made one particularly terrible argument that I'm going to eviscerate him on, his argument that he made in this Discord chat that because I have problems with the Bragg trial, "Oh, sure, Rob, you're right." And I'm quoting now, "The entire legal system is wrong." That's his argument. The entire legal system says that the Bragg trial was on the up and up and Trump's guilty. That's what the entire legal system says. And how dare I? Do I think I'm smarter than the entire legal system? Now, never mind the fact that Conor's talked routinely about how the entire legal system was covering up for the Bidens, and it took these whistleblowers coming out and blah, blah, blah. Now he just says, "But they're going after Hunter. That's good enough." So we'll talk a lot about the entire legal system. But Conor is someone that I think is arguing in good faith. He just makes a shitty argument. He's done some dumb shit, and he has some shitty opinions. But I like Conor. I think he's smart. Pisco, I think, smart. I do. But he is, and I mean this, and I'm saying this honestly, he is probably the most bad faith person I've debated. I can't think of an example, and I mean that, I mean even in college when I debated people, I can't think of a more ridiculous example of just a blatant bad faith person then you go through the whole syllogism of like, okay, did you ever see that meme where it's like SpongeBob and it's Patrick and Man Ray, and Man Ray's like, this wallet has your ID in it, right? Yeah. And it has a check written out to you, right? Yeah. And so therefore it must be your wallet. And he's like, no. That's what it's like. It's like, you said that it's inconceivable that Bowman didn't intend for the alarm to go off. Yeah. And you said that if he lied to police, that he should be charged. Lying to police materially is serious and we should charge it. Yeah. And so he said that he told police that he didn't intend for the alarm to go off. So therefore, you say he should be charged. No. But that's what you said. No, because when he said, I didn't intend, what he really meant was I did intend. I can't think of an analogy. I can't think of a hypothetical more ridiculous than that. I really can't. It'd be like, we go out. He goes, do you want to go get lunch? I'm like, nah, I don't want to get lunch. I already ate. He's like, oh. Then later we go and I meet his family. And they're like, hey, did Pisco take you out to lunch? I was like, no, I'm starved. I haven't eaten yet. And he'd be like, but you told me you ate. And I said, no, you told me you already had lunch. I said, no, when I told you I had lunch, what I meant was I hadn't had lunch. That's what I meant. Clearly. Right? Thoughts on love to eat. Says thoughts on Nick Rekieta. I can't claim to have been an avid Rekieta watcher, but that's because I consume very little of other streams. I've seen him. Particularly saw him debating Destiny on the alternate electors things. I think I've seen him with Viva Frey and Robert Barnes before. I think he seems like a really smart dude. I think he probably seems like someone who knows more about the law than me. As far as his personal issues, addiction sucks. I know there are claims. I've heard that the warrant that was used to get him, that his due process was violated. I don't know anything about that. I'm not going to pile on a dude, though. I wouldn't pile on a dude I didn't like for a problem like that. And I'm certainly not going to pile on a dude that, to me, looked like someone who was a smart guy that had interesting content. So, if his due process was violated, I hope that he is able to prove that and receives justice. If, he ends up going to jail or whatever, I wish him well. And as far as issues of, his alleged addiction and stuff, I hope he gets help. I hope he ends up living a life that he's happy with, but I don't have a hot take. That's it. I'd say the same if it was Destiny that got busted for the same thing. I'd say, Dave Smith versus Andrew Wilson. Yeah, I heard about that. That's great. They should have had me moderate it. I would have loved it. I wonder who is moderating that, to be honest. Yeah, Aftershock. That's a ridiculous Conor argument. If you just want to sleep with a porn star, sure. Right. I mean, that's such a... Everybody knows how stupid of an argument that is. If they locked Trump up for speeding and, gave him the death sentence, Conor would be like, well, he shouldn't have speeded. Driving too fast, but, you shouldn't do that. You should know better. Okay, dude. Great take. I don't know. I hope Andrew and Dave both do well. I like Dave. I'm probably closer... I don't know. I would say I'm probably closer ideologically to Dave Smith than though I don't know. It depends on how crazy libertarian he is. I don't think he's total ANCAP. I would say I probably lean closer to Dave Smith because I'm libertarian adjacent more than Andrew Wilson. But I probably like Andrew Wilson more just because I know him more. And like I said, yeah, the Dave Smith Cuomo thing, that should go in the Debate Hall of Fame. I mentioned this the other day. I put on Twitter, I wasn't asking for money or anything, but I put on that I blew a tire and I was with my family, and how in the past that would have been something that pissed me off for a couple weeks because it cost me a decent chunk of change to replace all the tires. But it was cool because I was with my family, and it's I'm sort of maturing a little where it's oh, it's all right. Your priorities are in different places. And immediately Andrew private messaged me and was like, how much were your tires? We'll pay for them at the Crucible. I mean, I have nothing as far... I think Andrew has arguments I disagree with. I think he's a good debater, but I don't think he's perfect. I I think there are arguments I disagree with him. I know he talks on issues that I normally don't talk. I'm not big into like debating the red pill people or going on things like debating the, OnlyFans girls. It's not my cup of tea. It's not what I watch. It's not what I do. But hey, some people like it. Good for them. I don't care. I don't think it makes you immoral or like, it's just not for me. I don't really have an interest in it. And I know he comes off as very aggressive and definitely confrontational. But again, I said the irony is I feel like most streamers try to put this face out like they're these really nice people, and then you find out they're pieces of shit behind the scenes. And obviously I don't know behind the scenes into Andrew's life a lot, but all the interactions I've had with him behind the scenes, he's been incredibly nice. So I have nothing negative to say. I don't know what the topic is. I heard someone mentioned it the other day that he was debating, and this is Vivas Frequency saying it there. That was the first I've heard of it since then. So I don't know. Maybe I'll message him and see what's going on. But you probably won't hear from me tomorrow. Wednesday, it's going to be a lot of streaming. Now understand, I'm here. I came into work Saturday morning. I'm here. I don't see my wife and kid all day Saturday, all day Sunday, all day Monday, all day Tuesday. And Wednesday, I go home at 2 o'clock. I really hate having to do a big, long live stream on Wednesdays because I haven't seen my family for like 3 or 4 or 5 days, depending, sometimes 11 days. And so when I get off on Wednesdays, it's like, shit, I wish I could just go to dinner with them and hang out with them. But instead, I'll be doing these 2 panels on Wednesday. So I hope people tune in, because it'd be a shame if I'm missing hanging out with the best wife and best kid in the world and no one really tunes in. It would be a shame. So I hope you're ready. I think it starts around 6 p.m. Eastern time. I will not be doing a lot of preparation on Wednesday. Now, hopefully tomorrow I have some time to write down a few notes, but I think I'm ready to go for both of those debates, to be honest. I know what I'm going to say. But this may mean that I'm not streaming much Thursday and Friday. Because I streamed yesterday, I streamed today. Normally I don't stream when I'm at work. So I tried to I knew that I got shit coming up Thursday and Friday. I knew I probably wouldn't be able to stream. So I really did try to it should be around 6 p.m. Eastern it starts. I think the first debate, I don't know if it starts at 6 or 6:30. I think it starts, let me see if Wick said. I think it's at 6 p.m. Eastern. Let me make sure it's Eastern. I was told specifically, 6 p.m. Eastern. I was told specifically that Lethwater Kai, or however you pronounce it, his panel always runs after Wick's. So I should be able to hit both of them. So his panel's at 6. And that's the one that Pisco and Pondering and me and Lactoid and Admiral Gibbs and Rashad will be on. And then the other panel I think starts at 8 or 8:30 p.m. So obviously I'm not going to... It'll be 6 to 8, and then I'll get a couple minutes before the second panel starts. Wick sucks. I kind of like Wick. I think he's like harmless. He's trying. He's putting in the hours. Trying to host debates and stuff. Listen, I'll tell you a secret. You ready? When it comes to the online debate sphere, here's the secret. There's debaters. Then there's moderators. And then there's the few that could do both. Wick's a moderator. I'll leave it at that. Some people create content, and some people bring other people on to create content. And that's how it goes. Now, I think I'm a damn good moderator, but I hate it. I do. I hate moderating, because the whole time I'm sitting there thinking, I would say this. Why the fuck isn't this person saying that? And I think I do a good job of being impartial, but damn, in my head, I'm like, God damn it. Especially if the side I want to win is losing. I don't like that. So yeah, I as far as Wick, he's been nice to me, and as a moderator, I don't think he's top tier or anything, but all I really want from a moderator is to give me a chance to say my piece. I don't give a shit if they, after I say it, say, you're a fucking idiot, you're wrong. Whatever. As long as I get to, I'll tell them they're an idiot right back. But as long as I get to talk. What I can't stand, like, a moderator that pissed me off, and I told them I would never do their show again, even though it's a person that I like, is Danabo. Danabo did a decent amount to help my Discord channel out. Helped set up, like, all the... He moderated a debate once, and he had this stupid-ass rule that was like, Remember this? I think it was like the steel chair rule, where if someone says, steel man my position, and you can't, then you're put on mute for like 5 minutes. And Demon Mama was on there and was like, steel man my position. And I did. And she was like, nope, that's not it. So I got muted for 5 minutes. So as soon as I came back on, I was like, steel man my position, Demon Mama. And she didn't accurately do it. And I said, okay, then mute her. And Danibo was like, no. And I said, okay, fuck you. I'm never doing your panel again. You're going to mute me and shit like that. And that's the rules. And you aren't going to apply them equally. Go fuck yourself. Find some other righty to come. Oh, wait. All the other righties that you could get are shit? Sorry, dude. I don't know. I should say shit. How about this? All the other righties you can get aren't as confrontational, as fun as me. And that's the truth of it. You have to understand. Right? The people that debate someone like me or someone like Andrew most of the time don't want to debate us because we're good. And the people that want to gatekeep and want their side to win, they don't want to have us there that are lefties. But the lefties that just want content, who's better than people like us? What are you going to do? Oh, we're having a panel about Trump being shit. We have 2 lefties, we have Pondering and Pisco, and our righties will be Jebtan and Conor. And all 4 of them are like, yeah, we agree. Wow, what an interesting panel. You guys nailed it. It's shit. You could hate me. You could hate Andrew. You could want to see us fucking lose and cry in the middle of the stream. But you want to see us. That's the truth. You don't want a panel where everyone's agreeing. You want someone to hate. You want someone, or if you're on our side, you want someone who can debate your position well. That's what you want. You don't want some milquetoast, oh, I guess. You know, I respectfully disagree, I guess, a little. Maybe you have a point. Well, you know, I'm a centrist, so... Wow. Woo! Well, that's true. People want confirmation bias. That's also true. But in the panels are deep down, you want entertainment. That's what you want. And it's fucking boring with all these other people. It's boring. That's the truth. In my estimation. All right, I'm out. I don't know how to raid people on YouTube, so... Thank you, everyone. Anyone who donated, thank you so much. I really appreciate it. If you didn't donate, fuck you. I'm just kidding. I totally get it. I don't know what I'm putting my money towards now. Tires, I guess. But no, thank you so much for your support. I really do appreciate it. You know, I do apologize. Sometimes I feel a little self-indulgent. I just did how many hours have been going? 3.5 hours. I just did a 3.5 hour stream, and probably 2 hours and 45 minutes of it was talking a meta argument about me and Pisco. But that's because I wanted to talk about it. And again, I told you at the outset, you would be mistaken to think from listening to me tonight, oh man, you want to know what a huge argument is? That Trump's team didn't know the charges. It's an argument. It's a serious charge, but it's not the most compelling argument as to why this was all bullshit. It's not. It's one of maybe the top 10. What about the new computer? I think the new computer's irrelevant at this point, if I'm honest. I can't stream much at work. Tonight was a little different. Basically, tonight, I'm in the office alone. But a change occurred at my work where I'm always required to be in the house. Now I'm required to basically be on call to deal with an emergency at the house as well. As weird as that sounds. So a new PC that I wanted would have been where I'm at my work office off the clock, but I'm not going to stream much at my work office. I only did it today because I promised, and I got stuck here because I was doing overtime. And so I waited till I was off the clock and started. But that's it. So it wouldn't be, if I bought a new PC, I might use it 6-7 times in 1 year. So it's just not worth the price. And if I have to stream, I could stream on my phone, because then I could hurry up and end the stream and do whatever I need to, as opposed to having a computer set out. So that's the way it'll be. When I'm not at home, if I am ever streaming, it's going to be on YouTube exclusively, just because that's the only thing it can handle. So, but all right, I am out. I'm going to go to bed. I got to take my medication now. Yay, old man. My company is, oh my God. Yeah, we'll just say that. They lost workers. It's crazy. It's just absolutely crazy. God, I this is the last thing I'm saying for real. So, like, the way it works is, my line of work, what happens is you have people with developmental disabilities, and the idea is, instead of having them in a big facility, like a hospital-esque facility or a psychiatric ward or something like that, you rent or purchase homes, and then it becomes that person's home. So the clients I work for is their home. And then you, as a staff member, are a direct support professional, and your job is to help them with their day-to-day lives and achieving their goals, etc. So depending on the level of care, you might help someone, you make them dinner, or you give them medication, or you drive them to work, or you drive them to their education program, or you help clean their house, or do laundry, or help them bathe, or whatever. Depending on different people, there's different levels of care. Some people require 24/7 supervision, so you have to be someone in a room with them 24/7. Some people, it's, you just have to be in the home, and they could, you need to be there for certain activities, but other than that, you just have to be within. Some people require 2-to-1, so you need 2 staff with the person at all times. The way they break down the workload is this: they break the week into 3 parts. Part A is Sunday, Monday, or part of Sunday, Monday, Tuesday, part of Wednesday. Part B is part of Wednesday, Thursday, Friday. Part C is part of Friday, Saturday, Sunday. That's how it works. So there should only be 3 people that work at my home that I'm normally at, 3 of us. So I should work 1/3 of the week. But we only have 2, which means I work half of the week. On a normal week, I work half the week. Okay, but here's where it gets tricky. There is a bunch of stuff you have to do through the state. Trainings you have to take, like a simple one, CPR training. So you have to be CPR trained, so I have to go to the training. My office is basically 2 hours away from where I live. So let's say I work Sunday, Monday, Tuesday, Wednesday. Okay, then Thursday I have to drive to the office for a training. Then every Friday that I'm not working, I have to drive to the office because I'm kind of in charge of our house, for like paperwork type purposes. Which means the only day I don't work on a normal week is Saturday. Normally. I don't always have trainings on Thursday, but a lot of times I do. So that means Sunday, now I'll grant Sunday, I usually come in at 3 p.m. So Sunday, I work half the day. And when I'm here 24/7. I'm not getting paid 24/7, but I'm here 24/7. So Sunday, half a day, all day Monday, all day Tuesday, Wednesday, half a day. Then I get to go home 2 o'clock. Thursday, usually about 8 hours when you factor in the drive. Same with Friday. So I guess Saturdays. That's it. And so and then on top of that, because we're losing, and it's been like that for 8 months, 7 months. And then on top of that, they're changing sort of what our job duties are and our regulations. So it's a lot. Now, I like what I do. I really do. But it's a lot. It really is. And it makes it difficult when you have a hobby. Like, let's say instead of streaming, my hobby was fishing. How much time do you think you'd get for fishing? Is Crisco in here? Well, if you want to hang out with your family and they don't like fishing, not much. Because at a bare minimum, I'm at work half the week. I'm away from my family at a minimum, literally half the week. And usually it's much more than that. So it's very hard on me, but especially hard and unfair to them when I'm like, hey, great, I'm home. Now I'm going upstairs to stream for 6 hours. Like, it's not fair to them. It really isn't. But they're cool with it. At least my wife's cool. I don't know how cool my son is with it. But that's why I've been streaming less. It's like, I'm trying to commit to streaming Wednesday, Thursday, Friday nights. I really am. But it's hard. It really is. It's just, what do I say to them? What do I say to my kid? Like, he starts crying now when I go upstairs to my office when I get home. He says, Dad's got to go to work. That's what he says. Because that's what I tell him. I could go upstairs and do some work. It sucks. It sucks, And it'd be different if this was my career. It's not. It's my hobby. And I'm clear with that with everyone, I think. I think I tell everyone, like, I do this for my own entertainment. So how do I tell my wife, basically, how is this any different, really, than me, like, coming home after my wife? And it's hard on her because she's there with a toddler by herself half the freaking week. And then as soon as I get home, like, what if I said instead of streaming, hey, I'm going upstairs to play Halo with my friends for 5 hours? And she'd be like, are you fucking kidding me? Like, you're not going to give me a break? Like, but that's basically what happens. I'm like, I got to go upstairs to do my hobby for 5 hours. So it's tough on all of us, but the time I do get to spend with my family is fantastic and the best. And I have no one to blame but myself because I fucked around and drank my face off in college. And so I was unable to parlay that into a good career where I was making big money and got to work less hours. So because I was a fuckhead for so many years, now I have to work crazy hours to provide for my family, and it's my fault. It really is. So I'm not blaming anyone. That's not what I'm doing. I'm just saying it does get to the point where I have to weigh, like, I feel like I owe the audience something. It's not fair to them. There's Crisco. There he is. Fishing probably. It's not fair to the audience, especially the people that, like, subscribe to me. If I go through a month and I don't stream but 4 or 5 times in 1 month, I feel like it's not fair. Like, I cheated people out of their money. So I try to make sure that I'm at least making that commitment where I'm putting a video up every day at noon on YouTube, and hopefully I'm live streaming Wednesday, Thursday, Fridays at least. But it's almost it's very difficult. I only had, the past 2 days have been a little different, but I really can't stream at work anymore. So this was different. So it's not that I don't want to. I like it. I really do, especially when I'm not at home because I'm not there anyways. If I wasn't streaming tonight, I would have been watching Netflix and fell asleep. So that's it. Wuthering Waves. I don't know what that is. So, look at that bald head. This is one of my favorite insults people tell me. Oh, you wear that hat because you're bald? You're covering it up? Yes, I tell my audience all the time. And quite literally, that's why I wear the hat. That there is no, which, in fact, even showing my bald head defeats the entire purpose of why I put the hat on in the first place. But I didn't put the hat on to stream. That's not why. I put the hat on years ago when I started to go bald. And now I just leave it on when I'm streaming. But I love that insult to me. Whoa, you're wearing that hat because you're bald? Yes! Got me. That's right. So, all right, we'll see y'all Wednesday around 6 o'clock. I'll probably be on a couple minutes before that. Thank you so much, everyone. As always, have a good one. Oh, there we go.